Hey there, welcome back. Tonight we're stepping into something different. Something older than most kingdoms, more enduring than empires, and somehow still running the show in ways you probably don't even realize. We're talking about Roman law, the legal code that refuses to die. Before we begin, if you find value in what we do here, take a second to hit that like button and subscribe. Tonight, let your thoughts drift softly into calm. In this whispered journey, we'll blend gentle storytelling with ambient sound, exploring the forgotten corners of myth, memory, and quiet wonder. There's no need to rush. Just breathe, listen, and let each word settle. So dim the lights, find your stillness, and let the story unfold. If this brought you peace, leave a gentle note below. Tell me which moment you liked most, or where in the world you're listening from. Your words help keep this calm little corner alive. A journey through marble halls, dusty scrolls, and courtrooms that echo across 2,000 years. Here's the thing. More than 2 millennia ago, in the forums and basilicas of ancient Rome, a group of stern-faced men in togas sat down and wrote laws. They carved them into bronze tablets. They debated them in open air. They argued, revised and codified until they had something that worked. A system, a structure. Rules that weren't just commands from a king's mouth, but ideas that could be written down, studied, and applied consistently. And here's the wild part. Those laws didn't die when Rome fell. They didn't crumble with the Colosseum or get buried under volcanic ash. They spread. They evolved. They survived plagues, invasions, the collapse of civilization itself. And today, whether you're signing a lease in São Paulo, getting married in Paris, or filing a lawsuit in Tokyo, there's a decent chance you're standing on legal ground that was paved by Romans who've been dead for 15 centuries. You probably don't think about it. Why would you? You wake up, go to work, pay your bills, maybe argue with your landlord about a leaky faucet. You don't sit there thinking, wow, this contract I just signed is based on principles developed during the reign of Emperor Justinian. But it is. The language might be different. The paper might be digital. But the bones of it, Roman. The logic, Roman. The assumption that 2 people can make an agreement and the state will enforce it, Roman. From civil rights to property law, from the idea that you're innocent until proven guilty to the notion that laws should be written down so everyone knows what they are. From international treaties to the way judges structure a trial. It's all there, quietly, invisibly, like plumbing. You don't see it, but without it, everything falls apart. Roman law is the foundation of what we call the civil law tradition. That's the legal system used by most of the world. Europe, Latin America, large chunks of Asia and Africa. Billions of people living under legal codes that trace their ancestry directly back to Rome. Even in places that use different systems, like England and the United States with their common law, Roman ideas seep through. The vocabulary, the concepts, the structure. You've heard the terms, even if you didn't know where they came from. Habeas corpus, sub pena, pro bono. These aren't just fancy words lawyers throw around to sound important. They're Latin, Roman Latin, still in use, still carrying weight. Because the Romans didn't just create laws, they created a language for talking about justice itself. But let's be honest, the Romans weren't saints. They enslaved millions. They conquered brutally. They fed people to lions for entertainment and called it justice. Their society was built on hierarchy, and their laws reflected that. If you were a citizen, great. You had rights, protections, a voice. If you weren't, you were property, or worse, invisible. And yet, despite all that, despite the cruelty and the contradictions, they managed to create something that outlasted their empire's darkest impulses. A system that could be adapted, refined, made better. The ideas were strong enough to survive even the ugliness of their origin. Because here's the paradox. Rome gave us the concept of legal equality, the idea that laws should apply to everyone. But they didn't actually believe it. Not fully. Not for everyone. It took centuries, revolutions, wars, and movements to expand those ideas into something closer to universal justice. But the seed was Roman. The framework was Roman, and the language we use to argue for a better world, still Roman. This isn't a story about perfection. It's a story about persistence, about how ideas, once written down and argued over and taught to the next generation, take on a life of their own. How a code written for a city-state on the Italian peninsula could become the blueprint for modern nations. How laws designed to govern togas and chariots could evolve to govern corporations and the internet. Tonight, we're going to walk through that journey. From the 12 tables, Rome's first written laws, all the way to the legal codes that govern your life right now. We're going to see how Roman law spread across Europe after the empire fell, how it was rediscovered, studied, and adapted, how it shaped everything from marriage contracts to human rights, and how, even now, in a world of smartphones and space travel, we're still living in the shadow of Rome. You might wonder why this matters. Why spend time thinking about ancient laws when we have our own problems, our own systems, our own failures to deal with? And that's fair. But here's the thing. You can't understand where you are if you don't know how you got there. And when it comes to law, justice, and the very idea that society should be governed by rules instead of the whims of the powerful, we got here through Rome. Every time you sign a contract, you're invoking Roman principles. Every time you hear about someone's rights being violated, you're speaking a language the Romans helped invent. Every time a court hands down a decision based on written law instead of a king's decree, that's Rome. Still breathing. Still shaping the world. The marble columns have crumbled. The aqueducts are ruins. The emperors are dust. But the laws endure. Quietly, rationally, ruthlessly. And tonight we're going to find out why. So settle in, let your mind wander through the centuries. We're going back, way back, to a time when Rome was just a city, not yet an empire. To a moment when someone decided that laws should be written down, visible to all, and not just whispered in the ears of the powerful. It was a radical idea then. It still is. Picture this. It's 450 BCE. Rome isn't the empire you've seen in movies. No Colosseum, no sprawling marble temples, no legions marching across continents. It's just a city. A collection of hills, muddy streets, and wooden buildings clustered along the Tiber River. The population is maybe 100,000 people. Farmers, merchants, craftsmen, soldiers, and nobles who think they own the place because, well, they kind of do. And here's the problem. The laws aren't written down. They exist, sure, but only in the memories of the patricians, the aristocratic class who run everything. If you're a plebeian, a commoner, you have no idea what the laws actually say. You just know that when you get dragged before a magistrate, he'll cite some rule you've never heard of, and suddenly you owe money or land or your freedom. It's a rigged game. And everyone knows it. The plebeians are angry. They've been angry for a while. They fight in Rome's armies. They pay taxes. They work the land. But they have no political power and no legal protection. The patricians can do whatever they want, and they justify it by saying, that's the law, except nobody can actually check if that's true, because the law is a secret. So, the plebeians do what any group of angry armed citizens would do. They threaten to leave. Just pack up and start their own city. It's called a secession, and it's not the first time they've done it. Rome needs its soldiers, its workers, its taxpayers. So the patricians begrudgingly agree to a compromise. They'll write the laws down, all of them, or at least the important ones, and they'll display them publicly so everyone can see. No more secret rules. No more aristocratic mumbling about ancient customs. The law will be visible, legible, and the same for everyone. In theory, a commission of 10 men, the decemviri, is appointed. They're sent to study the laws of other cities, particularly the Greek colonies in southern Italy, because apparently even back then people understood that you should look around and see what's working elsewhere before you reinvent the wheel. When they return, they draft a set of laws. 12 tables. Bronze tablets, actually, inscribed with rules governing everything from property rights to marriage to theft to procedure in court. The 12 tables are displayed in the Roman Forum, the heart of the city, where anyone can walk up and read them. If you can read, that is. Most people can't. But even if you're illiterate, the fact that the laws exist in physical form, that they're not just floating around in some patrician's head, is revolutionary. It's a shift from trust us to, here it is, judge for yourself. Now, let's be clear. The 12 tables aren't some enlightened document of human rights. They're harsh, brutal even. If you're in debt and can't pay, your creditor can literally take you as a slave. If you're caught stealing at night, you can be killed on the spot. If you insult someone in public, you might get flogged. There are rules about how wide your roads should be, how to handle boundary disputes, and what happens if your neighbour's tree drops fruit on your land. Spoiler, you get to keep the fruit. But here's what matters. It's written. It's public. It's the beginning of the idea that law is something external to the rulers, something that exists independently, something that even the powerful have to acknowledge, at least in principle. The 12 tables become the foundation of Roman law. For centuries, Roman schoolchildren memorize them. They're quoted in courts. They're referenced in later legal texts. And even as Rome grows, conquers and evolves, these 12 bronze tablets remain the bedrock, the ore text, the starting point. But Rome doesn't stay small. Over the next few centuries, it expands. First across Italy, then across the Mediterranean. It defeats Carthage, conquers Greece, absorbs Egypt and sprawls into Gaul, Hispania, Britannia and beyond. And with each conquest, the legal system has to adapt. Because now you're not just governing a city of farmers and soldiers. You're governing millions of people across dozens of cultures, languages and traditions. The Romans are pragmatic. They don't try to force everyone into the same mould. Instead, they develop a flexible legal framework. Roman citizens have one set of rights. Non-citizens have another. There are laws for trade, laws for war, laws for provinces, laws for slaves. It's complicated, messy, sometimes contradictory, but it works, more or less, because the Romans are obsessed with organisation. Enter the jurists. These are legal scholars, not priests or kings, but professionals who study the law, interpret it, and advise on it. They write treatises. They debate in public. They create commentaries on the 12 tables and on the edicts issued by magistrates. They develop principles, concepts, categories. They turn law from a blunt instrument into a science. One of the key ideas they develop is the distinction between different types of law. There's ius civile, the civil law, which applies to Roman citizens. Then there's ius gentium, the law of nations, a set of rules used in dealing with foreigners and in international relations. It's more flexible, more universal. And then there's ius naturale, natural law, the idea that some principles are universal, derived from reason and nature itself, applicable to all human beings regardless of where they're from. This last one, natural law, is a big deal. It's the seed of an idea that will grow into something much larger. The notion that justice isn't just whatever the state says it is, that there are moral truths that transcend borders, cultures and governments. It won't be fully realised for centuries, but the Romans plant it. As the Republic gives way to the Empire, the legal system becomes even more centralised. Emperors issue decrees. The Senate passes laws. Jurists write opinions that carry the weight of precedent. And all of this gets recorded, copied and disseminated across the empire. By the time you get to the later empire, Roman law is a vast, sprawling body of texts, thousands of rulings, hundreds of jurists, centuries of accumulated legal wisdom. And then comes the problem. It's too much. Nobody can keep track of it all. Different regions interpret things differently. Old laws contradict new ones. The system is buckling under its own weight. Rome itself is in decline. The Western Empire is fracturing. Barbarian kingdoms are carving up the territory. And the legal tradition, this incredible edifice built over 1,000 years, is in danger of being lost. Enter Justinian. He's the emperor of the Eastern Roman Empire, ruling from Constantinople in the 6th century. The West has already fallen. Rome itself is a shadow. But Justinian has ambitions. He wants to reconquer the lost territories. He wants to restore the glory of Rome. And he wants to do something about the legal chaos. So he commissions a project. A massive, audacious project. He gathers the best legal minds of his time and tells them, compile everything. Every law, every ruling, every commentary. Organize it. Edit it. Cut out the contradictions. Make it coherent. Make it usable. The result is the Corpus Juris Civilis, the body of civil law. It's published in several parts over the course of a few years in the 530s. There's the Codex, a collection of imperial laws. The Digest, a massive compilation of writings by the great Roman jurists. The Institutes, a textbook for law students. And later, the novels, new laws issued by Justinian himself. It's not just a collection, it's a systematization. The compilers don't just copy everything down, they edit. They synthesize. They create a logical structure. They turn 1,000 years of legal thought into something organized, accessible, and teachable. And here's the kicker. Justinian's empire doesn't last. He reconquers parts of Italy and North Africa, but it doesn't stick. Within a few generations, much of it is lost again. Justinian's dream of restoring Rome dies with him. But the Corpus Juris Civilis? That survives. Copies are made. They're preserved in monasteries. They're studied in the universities that will emerge centuries later, and when Europe finally starts to pull itself out of the chaos of the early Middle Ages, when kings and scholars start looking for models of governance, of law, of civilization, they find Justinian's code sitting there, waiting. The Roman Empire falls, but Roman law doesn't. It goes underground. It hibernates. And when the world is ready for it again, it wakes up. Because empires fall, cities burn, dynasties collapse. But ideas, once written down, once codified, once taught, have a way of outliving everything else. They slip through the cracks. They cross borders. They wait. And Roman law is patient, very patient. Fast forward. It's now the early Middle Ages, let's say 600, 700, 800 CE. Rome has fallen. The Western Empire is gone. Europe is a patchwork of barbarian kingdoms. Franks, Visigoths, Lombards, Saxons. They've carved up the old Roman territories and made them their own. The cities are smaller. Trade has collapsed. Literacy has plummeted. The grand infrastructure, the roads, the aqueducts, the public baths, most of it is crumbling or abandoned. And the law? Well, that's complicated. The Germanic tribes that now rule Europe have their own legal traditions, trial by combat, ordeals, blood feuds. Justice is personal, tribal, and often violent. If someone kills your brother, you don't take them to court. You kill them back, or their family does. Or someone pays compensation. It's rough. Chaotic. Effective in its own way, but not exactly systematic. Roman law still exists, technically. In some places, the old Roman population continues to follow Roman legal customs, at least loosely. The Visigoths in Spain even create a legal code that blends Roman and Germanic traditions, but for the most part, Justinian's Corpus Juris Civilis is gathering dust. Literally. Copies sit in monasteries, unread, waiting. Because here's the thing. Nobody needs it. Not yet. Europe is agrarian, localized, and fragmented. There's no centralized state, no bureaucracy. No need for complex legal systems. If you're a peasant farming a lord's land, you're not signing contracts or filing lawsuits. You're just trying to survive. But then, slowly, things start to change. By the 11th century, Europe is waking up. The population is growing. Trade is picking up. Cities are emerging again. Merchants are traveling longer distances, making deals, forming partnerships. And suddenly, people need rules. Not just don't kill each other rules, but commercial rules. How do you enforce a contract? What happens if someone defaults on a debt? Who owns what when a business partnership dissolves? The old tribal customs don't have answers for this. They weren't designed for commerce, for complexity, for urban life, so people start looking around for something better. And that's when they rediscover Justinian. It happens in Italy first, specifically in Bologna, a city in northern Italy that's becoming a hub of trade and learning. In the late 11th century, a manuscript of the Digest, one of the key parts of Justinian's corpus, is found. Maybe it was always there, hidden in some monastery library. Maybe it was brought from the East. Historians argue about the details. But what matters is this: someone finds it, reads it, and realizes what they're looking at. It's not just an old book. It's a blueprint, a fully developed legal system, organized, logical, comprehensive. It has rules for contracts, property, inheritance, torts, procedure. It's everything a growing, increasingly complex society needs. And it's written in Latin, which is still the language of education and the church, so scholars can actually read it. A man named Irnerius, a teacher in Bologna, starts lecturing on the Digest. He goes through it line by line, explaining the principles, interpreting the difficult passages, showing how the Roman rules could apply to modern situations. Students flock to hear him. Not just from Bologna, but from all over Europe. Because this is new, exciting, revolutionary. And here's the genius of it. Irnerius and his followers don't just read the text passively, they engage with it. They write glosses, marginal notes explaining and elaborating on the Roman jurists' ideas. They debate, they argue, they apply logic and reason to legal problems. They turn the study of law into an intellectual discipline, something that can be taught systematically in a university setting. The University of Bologna becomes the first great law school in Europe. And it's not teaching Germanic customs or church canon law, though those exist too. It's teaching Roman law, Justinian's law, the ius civile. Students come from France, Germany, Spain, England. They spend years studying the texts, mastering the principles, and then they go home and take those ideas with them. This is how Roman law spreads. Not through conquest, not through imposition, but through education. Through books. Through ideas that prove themselves useful. Kings and princes start hiring these university-trained lawyers as advisors, because Roman law offers something powerful: legitimacy. See, if you're a medieval king trying to centralize power, trying to build a state out of a mess of feudal territories, you need a legal framework that puts you at the top. And Roman law, conveniently, has a lot to say about imperial authority. The emperor's word is law. The state has sovereignty. There are rules, yes, but the ruler is the source of those rules. It's perfect for ambitious monarchs. The French kings use it. The Holy Roman emperors use it. The Spanish kings use it. They don't adopt it wholesale, not at first. They blend it with local customs, with feudal traditions, with church law. But the Roman skeleton is there, underneath. By the 13th and 14th centuries, Roman law is everywhere in Europe. It's taught in universities across the continent: Paris, Oxford, Salamanca, Prague, Padua, Krakow. Every major centre of learning has a faculty of law, and they're all studying the same texts. The Digest, the Code, the Institutes. Justinian's work becomes the common legal language of educated Europeans. And here's the thing, it's not just lawyers who care. Roman law shapes the way people think about justice, about rights, about the relationship between individuals and the state. It introduces concepts that didn't exist in the old tribal systems. The idea of legal personality, that a corporation or institution can own property and make contracts. The idea of representation, that someone can act on your behalf legally. The idea of jurisdiction, that different courts have authority over different matters. It's a wholesale reimagining of how society is organised, and it happens gradually, over centuries, but once it takes hold, it doesn't let go. The Church, meanwhile, develops its own legal system, canon law, but it's heavily influenced by Roman principles. Church courts use Roman procedural rules. They cite Roman jurists. They structure their arguments using Roman logic. Even when they're dealing with theology and sin, they're thinking like Romans. By the time you get to the Renaissance, Roman law is so embedded in European thought that people start to see it as natural, obvious, the way law should be. When scholars talk about reviving classical antiquity, they don't just mean art and philosophy, they mean law too. Roman law is part of the classical heritage, something to be studied, admired, and emulated. And then something else happens. Europe starts expanding, colonizing, conquering. Spanish and Portuguese ships sail to the Americas. The Dutch and British establish trade empires in Asia. The French push into Africa, and wherever they go, they bring their legal systems with them, systems rooted in Roman law. So now you have Roman legal principles spreading not just across Europe, but across the world. They're imposed on indigenous peoples. They're used to structure colonial governments. They're adapted to local conditions, but always with that Roman core. Property law, contract law, procedural law. It all traces back. Even in places that resist, that develop their own legal traditions, Roman law seeps in. Because by this point, it's not just a European thing. It's become the default, the international standard. If you want to trade with European powers, you need to speak their legal language. And that language is Roman. By the 18th and 19th centuries, the process reaches its peak. European states start codifying their laws, creating comprehensive legal codes that organize everything systematically. And the model they use? Justinian. The structure, the categories, the logic, it's all there. The Napoleonic Code, created in France in 1804, is the most famous example. Napoleon wants to unify French law, which is a mess of regional customs and royal decrees. So he commissions a team of jurists to write a clear, comprehensive civil code. They study Roman law. They borrow heavily from it. And when they're done, they've created something that's both modern and ancient. A 19th century legal code built on 2,000-year-old principles. And the Napoleonic Code doesn't stay in France. Napoleon's armies conquer much of Europe, and wherever they go, they impose the code. Belgium, Italy, the Netherlands, parts of Germany, Poland, Spain. Even after Napoleon falls, many of these places keep the code. They like it. It works. And it spreads beyond Europe. Louisiana, a former French colony, adopts a version of the Napoleonic Code. It's the only US state with a legal system based primarily on civil law rather than English common law. Latin American countries, newly independent from Spain and Portugal, create their own civil codes based on the Napoleonic model, which means they're based on Roman law. Japan, trying to modernize in the late 19th century, looks to Europe for legal models. They study French and German law. They adopt a civil code based on Roman principles. Same with Turkey, same with Thailand, same with dozens of other countries trying to build modern legal systems. By the 20th century, Roman law, or at least its descendant, the civil law tradition, is the most widespread legal system in the world. More countries use it than any other system. And even in countries that use common law, like England and the United States, Roman influence is everywhere. In the vocabulary, in the concepts, in the way lawyers and judges think about legal problems. You might be sitting in a common law country right now thinking this doesn't apply to you. But look closer. When a judge talks about a legal principle being prima facie valid, that's Latin, that's Roman. When a lawyer argues about precedent, they're using a concept the Romans developed. When you sign a contract and expect it to be enforceable, you're relying on a Roman idea that agreements create binding obligations. Roman law didn't spread because it was perfect. It spread because it was useful, adaptable, logical. It offered a way to organize society, to resolve disputes, to create predictability in an unpredictable world. And once people saw that it worked, they kept using it. They modified it. They improved it. But they didn't abandon it. Because here's the truth. Once an idea proves itself, once it becomes embedded in institutions, in education, in the way people think, it's almost impossible to dislodge. You can overthrow governments. You can redraw borders. You can start revolutions. But the legal principles, the underlying logic, those persist. The Roman Empire fell in 476 CE. That's the official date, give or take. But Roman law didn't fall. It went into hibernation, waited for Europe to be ready, and then came roaring back. And when it did, it didn't just influence a few countries, it reshaped the world. So the next time you sign a lease, or make a will, or sue someone in small claims court, or even just hear a lawyer on TV throwing around Latin phrases, remember, you're participating in a legal tradition that's older than most religions, older than most languages, older than the idea of the nation-state itself. Rome is gone, but its laws are still here, quietly, invisibly, running in the background like code in a computer program, and most people never even notice. But you do now. So here we are. Roman law has survived the fall of an empire, hibernated through the Dark Ages, been rediscovered by medieval scholars, and spread across Europe through universities and ambitious kings. It's been adapted, modified, codified, and exported around the world. But what does that actually mean for you? For the average person living in the 21st century, scrolling through their phone, paying bills, maybe dealing with a fender bender or a landlord dispute? It means everything and nothing, both at once. Because Roman law is so deeply embedded in the structure of modern legal systems that you don't see it. It's invisible. It's the water you're swimming in. But once you know what to look for, you start seeing it everywhere. In the way courts operate, in the language lawyers use, in the logic behind contracts and property rights, in the very idea that law should be written, organised and applied consistently. Let's start with the big picture. Today, there are roughly two major legal traditions in the world: civil law and common law. Civil law, also called the Romano-Germanic tradition, is based on Roman principles. It's used in most of Europe, all of Latin America, large parts of Asia and Africa, and even some places you wouldn't expect, like Louisiana and Quebec. We're talking about billions of people. The majority of the world's population lives under legal systems rooted in Roman law. Common law, on the other hand, developed in England and spread to its former colonies, the United States, Canada, Australia, India, and others. It's based less on codified rules and more on judicial decisions, on precedent. But even common law countries are saturated with Roman influence, the vocabulary, the concepts, the procedural structures. It's all there, lurking beneath the surface. So let's dig in. Let's see exactly how Roman law shaped and continues to shape the legal world you live in. Even if you've never set foot in a courtroom, even if you've never read a single legal document, it's there, affecting your life in ways both profound and mundane. First, the civil law tradition itself. This is the most obvious and direct legacy of Rome. Countries that use civil law have comprehensive legal codes, big thick books that lay out the rules for everything. Contract law, property law, family law, tort law, criminal law. It's all written down, organised into sections and articles, designed to be systematic and complete. The idea is simple. If you want to know what the law is, you look it up. You don't need to wade through hundreds of years of court cases trying to figure out what judges have said in the past. You just open the code and read. It's right there. Clear. Accessible. In theory, anyway. This is a Roman innovation. Before Rome, most societies had customary law, rules that existed in oral tradition, passed down through generations, interpreted by elders or priests. The Romans said no. Write it down. Make it public. Make it knowable. The 12 tables were the first step. Justinian's corpus was the culmination, and modern civil codes are the heirs. Take the Napoleonic Code, officially called the Civil Code of the French. It's organised into 3 books: persons, property, and the acquisition of property. Clean. Logical. Each section breaks down into titles, chapters, and articles. Article 1134, for example, states that agreements lawfully entered into have the force of law between the parties. That's Roman. That's the principle of pacta sunt servanda. Agreements must be kept, straight out of classical Roman jurisprudence. The German Civil Code, the BGB, is even more systematic. It's a monument to legal logic. It has a general part that lays out principles applicable to the entire code, and then specific sections on obligations, property, family, and inheritance. It's dense, precise. Some say it's beautiful if you're into that sort of thing, and it's entirely Roman in structure and spirit. These codes didn't just stay in Europe. When Latin American countries gained independence in the 19th century, they needed legal systems. They looked to Europe. They adopted civil codes modelled on the Napoleonic Code. Argentina, Chile, Brazil, Mexico, all of them. They tweaked things, adapted to local conditions, but the foundation was Roman. Same thing happened in Asia. Japan modernized rapidly in the late 1800s. They studied Western legal systems and adopted a civil code based on German and French models. China did something similar in the early 20th century. Even after the Communist Revolution, Chinese law retained civil law structures, though heavily modified by socialist ideology. And when China opened up economically in the late 20th century, guess what? They went back to civil law principles for commercial and contract law. So that's the structural legacy. The idea that law should be codified, systematic, and written. But it goes deeper. It's not just about the format, it's about the concepts themselves. The categories, the way lawyers think about legal problems, and that's where things get interesting. Roman jurists were obsessed with classification. They loved dividing things into categories, creating taxonomies, defining terms. They asked questions like, what is ownership? What is possession? How are they different? What is a contract? What makes an agreement legally binding? What is a delict, a wrongful act that creates liability? These questions sound abstract, but they have real consequences. Because how you define ownership determines who gets to keep the house in a dispute. How you define a contract determines whether you can sue someone for backing out of a deal. How you define wrongful conduct determines whether you can get compensation for an injury. And the Romans worked all this out, painstakingly, over centuries. They created legal categories that are still used today. Let's take property law. The Romans distinguished between ownership and possession. Ownership is the legal right to something. Possession is the physical control of it. You can possess something without owning it. You can own something without possessing it. Sounds simple, but it's a crucial distinction, and it underpins property law around the world. They also developed rules for how ownership is transferred. You can't just say, this is mine now. There has to be a process, a ceremony, a contract, a transfer of possession. The Romans had elaborate rules about this, and modern property law, whether you're buying a car or a condo, follows the same logic. You sign documents, you exchange keys or titles. There's a formal process because Roman law said there should be. Then there's contract law. The Romans were masters of this. They understood that commerce requires trust, and trust requires enforcement. If I agree to sell you grain and you agree to pay me, but then you don't pay, I need some way to get my money. Otherwise, why would I ever do business with you? So the Romans created a system of contractual obligations. They categorized different types of contracts: sale, lease, partnership, loan, deposit. Each had its own rules, its own requirements, its own remedies if things went wrong. And they developed the principle that a lawful agreement creates a binding obligation. You can't just back out because you changed your mind. Your word is your bond. Or in Latin, pacta sunt servanda. This principle is everywhere in modern law. Every time you sign a lease, you're invoking it. Every time you click I agree on a terms of service, you're invoking it. Every time a court enforces a contract, they're applying a Roman idea. The specifics have evolved, sure. We have consumer protection laws now. We have regulations about unfair terms. But the core concept that agreements create obligations, that's Roman. And it's not just contracts, it's torts too. That's legal jargon for wrongful acts that cause harm. If you hit someone with your car, if your dog bites a neighbour, if you spread lies about someone and damage their reputation, that's a tort, and you can be held liable. You can be sued. You might have to pay damages. The Romans called this lex aquilia after a law passed in the 3rd century BCE. It said that if you wrongfully damage someone's property or injure their slave, you have to compensate them. Over time, Roman jurists expanded this. They developed principles of fault, of negligence, of liability. They asked, did you intend the harm? Were you careless? Could you have prevented it? These questions are still at the heart of tort law today. When a court determines whether you're liable for a car accident, they're asking Roman questions. Were you at fault? Did you act reasonably? Could a reasonable person have foreseen the harm? The language has changed. The context is different. But the logic is Roman. Even family law bears Roman fingerprints. The Romans had detailed rules about marriage, divorce, guardianship, adoption, and inheritance. Some of these rules were harsh. Women had limited rights. Fathers had almost absolute authority over their children. But the structure, the categories, the way of thinking about family relationships in legal terms, that persists. Modern family law has evolved enormously, thankfully. We've expanded rights. We've recognized equality. We've protected children. But we're still using Roman concepts. The idea of legal guardianship, the idea of testamentary freedom, that you can decide who inherits your property through a will, the idea that marriage is a legal contract with specific rights and obligations, all Roman. And then there's inheritance law. The Romans were pioneers here. They developed the concept of a will, a legal document that expresses your wishes about what happens to your property after you die. Before Rome, inheritance was usually customary. The eldest son gets everything, or it's divided among male heirs, or the tribe decides. The Romans said no. You should be able to choose, within limits, of course. You can't disinherit your children entirely without good reason. But you have significant freedom. This idea spread everywhere. Today, in most legal systems, you can write a will. You can leave your house to your daughter, your car to your son, your money to a charity. You can even leave it to your cat, sort of. And if you die without a will, there are default rules, usually based on family relationships, but those rules also trace back to Roman principles. So that's the substance. The concepts, the categories. But what about procedure? How does Roman law influence the way courts actually operate, the way trials are conducted, the way judges make decisions? A lot. More than you'd think. Roman legal procedure was surprisingly modern. They had courts, they had judges, they had advocates, basically lawyers, who argued cases on behalf of clients. They had rules about evidence, about burden of proof, about what made a valid argument. And they wrote it all down. Treatises on rhetoric, on legal argumentation, on how to structure a case. This wasn't just tradition. It was a science. One of the key Roman contributions is the adversarial structure. You have two sides, a plaintiff and a defendant. The plaintiff brings the case, makes accusations, presents evidence. The defendant responds, offers a defense, presents their own evidence. A neutral judge or panel evaluates both sides and makes a decision. This structure is fundamental to modern legal systems, both civil and common law. The Romans also developed the concept of legal representation. You didn't have to argue your own case. You could hire someone trained in law and rhetoric to do it for you. This created a professional class of advocates, the ancestors of modern lawyers, and with that came rules about professional conduct, about ethics, about what advocates could and couldn't do. Another Roman innovation, written pleadings. Before trial, both sides submit documents outlining their case. What they're claiming, what facts they're relying on, what legal principles apply. This allows the judge to understand the dispute before hearing arguments. It makes the process more efficient. And it's standard practice in civil law countries today. Even in common law countries, you file briefs, motions, complaints. Same idea. Roman idea. And then there's evidence. The Romans understood that you can't just make accusations. You have to prove them. So they developed rules about what counts as evidence, witness testimony, documents, physical objects. They asked, is this evidence reliable? Is it relevant? Does it actually prove what you're claiming? They also understood the concept of burden of proof. If you're accusing someone, the burden is on you to prove it. The accused doesn't have to prove their innocence. They just have to create reasonable doubt. Sound familiar? That's because it's a Roman principle. It's the foundation of the presumption of innocence, one of the cornerstones of modern criminal law. Now, the Romans didn't always apply this fairly. Torture was used to extract confessions, especially from slaves. Trials could be biased, corrupt, or rushed. But the principles they articulated, the ideals they aspired to, those survived. And over time, they were refined, expanded, and made more just. Take the concept of due process, the idea that you can't be punished without a fair procedure, that you have a right to know the charges against you, to confront your accusers, to present a defense, to have a decision made by an impartial judge based on law, not whim. This is Roman. It's articulated in the Digest, in Justinian's Code, in the writings of Roman jurists, and it's enshrined in modern constitutions. The US. Constitution's 5th and 14th Amendments guarantee due process. The European Convention on Human Rights guarantees a fair trial. These aren't just abstract ideals. They're enforceable rights, and they trace directly back to Roman legal thought. Even the vocabulary of law is Roman. And this isn't trivial. Language shapes thought. The words we use to describe legal concepts influence how we think about justice, rights, and obligations. Habeas corpus. Literally, you have the body. It's a legal order that requires someone detained to be brought before a court. It's a protection against unlawful imprisonment. The phrase is Latin, and while the specific writ developed in English common law, the concept, the idea that detention must be legally justified, is Roman, sub poena. Under penalty, it's a command to appear in court or produce documents. If you ignore it, you face punishment. The word is Latin. The concept is Roman, pro bono, for the good. It refers to legal work done for free for the public good. Again, Latin, Roman, amicus curiae, friend of the court, someone who's not a party to a case but offers information to help the judge. Latin, Roman, prima facie. At first face, it means evidence that, unless contradicted, is sufficient to prove something. Latin, Roman, mens rea, guilty mind. It's the concept that for most crimes, you need not just a wrongful act, but also intent. You have to mean to do it. This is a cornerstone of criminal law, and it's Roman. They understood that accidentally killing someone is different from murdering them. The act might be the same, but the intent matters. Actus reus, guilty act, the physical component of a crime. Roman, in loco parentis. In the place of a parent, it means someone acting with parental authority, like a school. Latin, Roman. The list goes on. Alibi, affidavit, de facto, de jure, ex post facto, quid pro quo. These aren't just fancy lawyer words. They're concepts, principles, ways of thinking about legal problems. And they're all Roman. Let's talk about something you probably don't think about, legal personality. It sounds abstract, boring even, but it's one of the most important concepts in modern law. And it's Roman. Here's the thing. In ancient societies, only humans had legal rights. You were a person, you could own property, make contracts, sue and be sued. But what about groups? What about organizations? Can a group of merchants own a ship together? Can a temple own land? Can a guild make contracts? The Romans figured this out. They developed the concept of the universitas, a legal entity separate from its members. A corporation, basically. It could own property. It could make contracts. It could sue and be sued, and it existed independently of whoever happened to be its members at any given time. Members could come and go, but the corporation continued. This was revolutionary. It meant you could create stable institutions, a business that outlived its founders, a charity that continued its work across generations, a city that held property for the public good. Without this concept, modern commerce would be impossible. Think about it. Every company you've ever worked for, bought from, or invested in is a legal person. Apple, Amazon, that coffee shop down the street. They're not just collections of people. They're entities with their own legal existence. They can own buildings, sign contracts, get sued. And when the CEO retires or dies, the company doesn't disappear. It continues. This is Roman. The exact mechanisms have evolved, sure. Corporate law has become incredibly complex. But the basic idea that you can create a legal person that's not a human being, that came from Rome. And it's so fundamental to modern economics that we don't even question it. Now, let's talk about something more tangible. Property. You probably own things. A phone. Maybe a car. Maybe a house. And you assume that ownership means something. That it gives you rights. That other people can't just take your stuff. But what does ownership actually mean? What rights does it include? Can you do whatever you want with your property? Can you destroy it? Sell it? Leave it to your kids? What if your property affects your neighbours? What if someone else has a claim to it? The Romans thought about this deeply. They distinguished between different types of rights in property. There's dominium, full ownership. That's the strongest right. It means you can use the property, consume it, destroy it, sell it, give it away. It's yours. Completely. But then there are lesser rights. Usufruct, the right to use something and enjoy its fruits, but not to destroy or permanently alter it. You can live in a house someone else owns. You can harvest crops from land you don't own. But you have to maintain it. You can't tear it down or sell it. There's servitude, the right to use someone else's property in a specific way, like a right-of-way. You can cross your neighbour's land to get to the road, but you can't build on it or exclude them from it. There's pledge, using property as security for a debt. If you don't pay, the creditor can take the property. These distinctions matter. Modern property law is built on them. When you get a mortgage, you're using Roman concepts. The bank has a security interest in your house. You have ownership, but if you don't pay, they can foreclose. That's a Roman idea, refined over centuries. When you rent an apartment, you have a lease. That's a Roman contract. You have the right to use the property, but not to own it. The landlord retains ownership, but can't just kick you out without cause. There are rules, obligations on both sides. The tenant pays rent and maintains the property. The landlord provides a habitable space and respects the tenant's possession. And it's not just about individual property. The Romans also developed the concept of public property, res publica, property owned by the state for the benefit of all citizens. Roads, aqueducts, temples, forums. These belong to the Roman people collectively, not to any individual or emperor. This concept underpins modern public infrastructure. Parks, libraries, schools, roads. They're owned by the government, held in trust for the people. You can't buy them. You can't sell them. They're public. And that idea that some things should belong to everyone, that's Roman. Then there's res communis, things common to all humanity. The air, the sea, rivers. In Roman law, these couldn't be privately owned. They were gifts of nature, available to everyone. This concept influenced international law, particularly the law of the sea. The idea that the oceans are global commons, that no nation can claim the entire sea as its territory, traces back to Roman thought. Now let's shift to something more immediate. Contracts. You make them all the time, even if you don't realize it. When you buy groceries, that's a contract. When you download an app, you're agreeing to terms of service, that's a contract. When you start a job, you sign an employment contract. When you rent an apartment, that's a contract. They're everywhere, and the basic principle behind all of them is Roman. Consensus facit legem. Agreement makes the law. If two people agree to something, and it's not illegal or immoral, the law will enforce it. Your word becomes binding. The state backs it up. The Romans developed different categories of contracts, each with specific rules. Sale, lease, partnership, loan, mandate, where you authorize someone to act on your behalf, deposit, where you give something to someone for safekeeping, Each had its own requirements, its own formalities, its own remedies if things went wrong. Modern contract law has expanded and evolved. We have employment contracts, insurance contracts, licensing agreements, franchise agreements, all sorts of things the Romans never imagined. But the underlying structure is the same. There's an offer, an acceptance, consideration, something of value exchanged. The Romans also understood that not all agreements should be enforceable. If someone forces you to sign a contract at knife point, that's not valid. That's duress. If someone tricks you into a contract by lying about material facts, that's fraud. The contract is voidable. If you make a contract while mentally incapacitated, while drunk or insane, it's not binding. You didn't have capacity. They're built into every modern contract law system. They protect people from being taken advantage of. They ensure that contracts are genuinely voluntary, that they reflect actual agreement. If you promise to do something and you don't do it, you've breached the contract. And the other party has remedies. They can sue you for damages. They can demand specific performance, that you actually do what you promised. They can rescind the contract and demand their money back. They're fundamental to commercial law. Without them, contracts would be meaningless. Commerce would collapse. So every time a business sues another business for breach of contract, every time a court awards damages, every time a judge orders someone to fulfill their obligations, Roman law is at work. Let's talk about something darker. Crime and punishment. The Romans had a sophisticated understanding of criminal law, at least by ancient standards. They distinguished between different types of crimes. And private crimes like theft or assault, which primarily harmed individuals. For public crimes, the state prosecuted. For private crimes, the victim or their family brought the case. This distinction influenced later legal systems. Criminal prosecution is brought by the state, by a district attorney or public prosecutor. Civil cases are brought by individuals. The Romans also developed the concept of proportionality. The punishment should fit the crime. You don't execute someone for petty theft. You don't fine someone for murder. There should be some rational relationship between the offence and the penalty. This idea that punishment should be proportionate is enshrined in modern human rights law. It's in the 8th Amendment to the US Constitution, which prohibits cruel and unusual punishment. It's in international human rights treaties, and it's Roman. But the Romans also pioneered something even more important, the idea of criminal intent. Mens rea. They understood that intent matters. If you kill someone accidentally, that's different from killing them on purpose. If you take something believing it's yours, that's different from stealing it, knowing it belongs to someone else. The act might be the same, but the mental state is different, and that affects guilt. Modern criminal law is built on this distinction. Murder requires intent to kill. Manslaughter doesn't. Theft requires intent to permanently deprive someone of property. If you borrow something intending to return it, that's not theft, even if you never actually return it. The law looks at what was in your mind, and that's a Roman concept. They also developed defenses. Self-defense. If someone attacks you and you fight back, you're not guilty of assault. You were protecting yourself. Necessity. If you're starving and you steal food, you might not be criminally liable. The circumstances matter. Insanity. If you're mentally ill and don't understand what you're doing, you can't be held fully responsible. These defences exist in modern criminal law. They're refined, elaborated, debated endlessly. But the core ideas are Roman. The recognition that context matters. That not every harmful act deserves punishment. That justice requires looking at the whole situation, not just the outcome. Now, the Romans didn't always live up to their own principles. Punishments were often brutal. Crucifixion, beheading, being thrown to wild animals. Torture was common, especially for slaves and non-citizens. The system was often arbitrary and corrupt, but the principles they articulated, the ideals they wrote down, those survived. And they became the foundation for more humane, more just legal systems. Let's talk about international law. The idea that there should be rules governing relations between states. that war has limits, that treaties should be honoured, that diplomacy should follow certain protocols. Where does this come from? Partly from Roman law. The Romans developed ius gentium, the law of nations. Initially, it was just the law applied in disputes involving foreigners, people who weren't Roman citizens. But over time, Roman jurists started to see it as something more. A set of principles common to all peoples, derived from natural reason, applicable beyond Rome's borders. This idea influenced later thinkers. In the 16th and 17th centuries, scholars like Hugo Grotius built on Roman concepts to develop modern international law. The idea that nations, like individuals, are bound by law, that treaties are binding, that aggression is wrong, that there are rules of war, that diplomacy should be conducted in good faith. These ideas seem obvious now, but they weren't always. For much of history, relations between states were governed by pure power. Might makes right. If you can conquer your neighbour, go ahead. The Romans weren't saints, they conquered brutally. But they also believed in treaties, in alliances, in legal frameworks for managing relationships. And that belief, formalised in ius gentium, became the seed of international law. Today, we have the United Nations, the International Court of Justice, treaties on human rights, on trade, on the environment. We have the Geneva Conventions governing war. The concept of crimes against humanity. All of this rests on the idea that there are universal legal principles, that law transcends national boundaries. And that idea, in its earliest form, is Roman. One more thing. Natural law, ius naturale. This is the Roman idea that some principles of justice are universal, derived from nature or reason, not from any particular government or culture. That there's a higher law, a moral law, that even kings and emperors should respect. This concept had enormous influence. Medieval scholars like Thomas Aquinas blended Roman natural law with Christian theology. Enlightenment thinkers like John Locke used it to argue for natural rights inherent to all human beings. The American Declaration of Independence invokes it. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. That's natural law theory. That's Roman. The idea that there are some rights so fundamental that no government can legitimately violate them. Freedom of conscience, freedom of speech, the right to a fair trial, the prohibition of slavery. These aren't just customs or preferences. They're moral truths, recognized by reason, and the legal system should protect them. Human rights law is built on this foundation. The Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, national constitutions around the world. They all assert that certain rights are universal, inalienable, and binding on all governments. And the intellectual ancestry of that assertion runs through Enlightenment philosophy, through medieval theology, all the way back to Roman jurists writing about ius naturale in the 2nd and 3rd centuries CE. So here we are, in the 21st century, living in a world of smartphones and social media, of global trade and instant communication. And yet the legal principles that govern our lives, that structure our societies, that protect our rights, are ancient. Roman. Refined over centuries, yes. Adapted to new circumstances, absolutely. But fundamentally the same. You sign a contract, that's Roman. You own property, that's Roman. You go to court, that's Roman. You invoke your rights, that's Roman. You expect the law to be written, public, and applied consistently, that's Roman. You assume that agreements should be kept, that wrongs should be compensated, that punishment should fit the crime, that intent matters, that justice should be rational, all of that is Roman. And the really remarkable thing, most people have no idea. They go about their lives, interacting with the legal system, without ever realizing they're walking on ground paved 2,000 years ago, by men in togas, arguing in Latin. But that's how deep ideas work. The really powerful ones don't announce themselves. They don't wave flags. They just become part of the infrastructure, invisible, essential. Like plumbing or electricity, you only notice when they're not there. Roman law is the plumbing of modern civilization. It's what keeps everything flowing, functioning, stable. And like plumbing, nobody thinks about it until something goes wrong. But it's there, always, quietly, holding everything together. You're sitting in a courtroom. Maybe you're there for jury duty. Maybe you're a witness. Maybe you're the one being sued or doing the suing. Doesn't matter. The point is, you're there. The room is formal. Wood paneling, a raised bench where the judge sits. The American flag, or whatever flag, belongs to your country, hanging in the corner. Everyone speaks in hushed tones until the proceedings begin. Then the bailiff says something like, "All rise," and the judge enters. Black robe, serious expression. They sit. You sit, and then the lawyer stands up and starts talking. And within about 30 seconds, you hear it. Latin. Your Honour, we move to introduce this document as prima facie evidence of the defendant's negligence. The plaintiff's claims lack a bona fide basis. We request the court issue a subpoena ducis tecum for the relevant records. If you don't have legal training, half of what's being said sounds like a foreign language. And that's because it is. It's Latin, the language of ancient Rome. And it's not just decoration. It's not lawyers showing off. Well, okay, sometimes it is. But mostly, it's because Roman legal terminology is so precise, so embedded in the system, that there's often no better way to say things. Let's break down why this matters. Language shapes thought. The words you have available determine what ideas you can express. If a language has 20 words for snow, speakers of that language can make distinctions that others can't. Legal Latin works the same way. It's a specialized vocabulary that allows lawyers and judges to communicate complex ideas efficiently and precisely. Take habeas corpus. Literally, you have the body. It's a writ, a type of court order that requires someone holding a person in custody to bring that person before a court and justify the detention. It's one of the most important protections against unlawful imprisonment in the common law tradition. You could say all that in English. A court order requiring that a detained person be brought before a judge to determine if their imprisonment is lawful. That works, but it's clunky. Habeas corpus is shorter, sharper, and because it's a technical term with a specific legal meaning, it's more precise. Lawyers and judges know exactly what it means. There's no ambiguity. The writ itself has a long history. It developed in medieval England, but the concept, the idea that detention must be legally justified, comes from Roman law. The Romans had similar procedures. If someone was holding you illegally, you could petition a magistrate for relief. The specifics were different, but the principle was the same. Your liberty matters. The state can't just lock you up without justification. Habeas corpus became a cornerstone of Anglo-American law. It's in the US. Constitution, Article 1, Section 9. The privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion, the public safety may require it. It's considered so fundamental that even during emergencies, suspending it requires extreme justification. And every time a court hears a habeas petition, every time a prisoner challenges their detention, every time a judge orders the government to justify holding someone, they're invoking a principle that traces back through English common law to Roman legal thought. The Latin phrase carries that entire history with it. Or take subpoena. Under penalty. It's a command from a court. You're ordered to appear as a witness, or to produce documents, or both. And if you refuse without a valid reason, you can be held in contempt. You can be fined, even jailed. There are different types. A subpoena ad testificandum requires you to testify. To testify, literally, a subpoena ducis tecum requires you to bring something with you. Documents. Records. Physical evidence. Bring with you, literally. Again, you could say this in plain English. Court order to testify. Court order to produce documents. But the Latin terms are standard. They're recognized internationally. A lawyer in New York and a lawyer in London both know what a subpoena ducis tecum is. The Latin creates a common language across borders. And it's not just convenience, it's precision. Legal Latin terms often have definitions refined over centuries of use. They've been interpreted in countless cases. They have established meanings. Using them reduces ambiguity. Take pro bono. For the good, it refers to legal work done without charge for the public benefit. Lawyers are generally encouraged, sometimes required, to do a certain amount of pro bono work each year. It's seen as a professional obligation, a way of giving back, of ensuring that justice isn't only for those who can afford it. You could just say free legal work, but pro bono carries connotations. It's not charity exactly. It's service. It's the idea that law is a profession with duties to society, not just a business. That meaning is embedded in the Latin phrase. It comes from the longer phrase pro bono publico, for the public good, a Roman concept. The idea that citizens, especially the educated and privileged, have responsibilities to the Commonwealth, or amicus curiae, friend of the court. This is someone who's not a party to a case, but files a brief offering information or arguments to help the judge. It happens a lot in appellate cases, especially ones dealing with important constitutional or policy questions. Advocacy groups, professional organisations, scholars, they'll file amicus briefs presenting their perspectives. The term comes from Roman law, though the specific practice developed more fully in English courts. The idea is that the court's job is to reach the right decision, and sometimes that requires input beyond what the immediate parties provide. An amicus offers expertise or highlights consequences the parties might not have addressed. They're helping the court, not their own interests. At least in theory. Then there's in camera. In a chamber. It means the judge considers something privately, not in open court. Maybe it's classified information. Maybe it's trade secrets. Maybe it's sensitive personal information. Whatever it is, the public doesn't get to see it. The judge reviews it alone or with limited parties present and then makes a decision. This is sometimes controversial. Justice requires transparency, but it also requires balancing competing interests. Sometimes privacy matters. Sometimes national security matters. The Romans understood this. Not everything could be public. Some things required discretion. The Latin term carries that nuance, ex parte. From one party, it refers to legal proceedings where only one side is present. Usually, both parties in a case get to be heard. That's basic fairness, but sometimes you need emergency relief and there's no time to notify the other side. A domestic violence victim seeking a restraining order, for example, or someone trying to freeze assets before they're moved overseas. The court hears from one party, makes a temporary decision, and then schedules a full hearing later where both sides can participate. The term signals something important. This is an exception to normal procedure. It's temporary. It needs justification. And it's presumed that a fuller hearing will follow. All of that is packed into two Latin words. De facto. From the fact, it means something that exists in reality, regardless of legal status. A de facto government is one that actually controls a territory, even if it's not legally recognized. A de facto parent is someone who's functioned as a child's parent, even if they're not the biological or adoptive parent. The law often recognizes de facto situations because reality matters. Sometimes what exists on paper doesn't match what exists in life, and the law has to deal with both. De jure. From the law, the opposite of de facto, it means something that exists legally, regardless of the reality. De jure, that government is legitimate. De facto, they've fled and someone else is in charge. The distinction matters. Legal status and actual status aren't always the same. Roman jurists understood this. They had to deal with it constantly. What do you do when the law says one thing but reality is different? You need language to talk about the gap. De facto and de jure give you that language. Ex post facto. From after the fact, it refers to retroactive laws, laws that punish conduct that wasn't illegal when it occurred. Most legal systems prohibit this. You can't criminalize something and then prosecute people for doing it in the past. That's fundamentally unfair. You can't follow a law that doesn't exist yet. The US Constitution explicitly bans ex post facto laws. Article 1, Section 9. The principle comes from Enlightenment thinkers, but they were drawing on older ideas, including Roman legal thought. The Romans understood that law needs to be prospective. People need to know what the rules are before they act. Surprise prosecutions undermine the rule of law. Quid pro quo. This for that. It means an exchange, something given in return for something else. In contract law, it's related to consideration. For a contract to be valid, both sides have to give something. That's the quid pro quo. I give you money, you give me a car. I give you labour, you give me wages. There's a mutual exchange, and that's what makes the agreement binding. The phrase has also taken on a darker meaning. In corruption cases, quid pro quo refers to exchanges of favours. A politician votes for a bill and a lobbyist gives them campaign contributions. A government official awards a contract and the contractor gives them a kickback. It's bribery, and it's illegal. But the Latin phrase captures the transactional nature of it. This for that. A corrupt deal. Then there's mens rea. We touched on this before, but it's worth going deeper. Guilty mind. It's the mental state required for criminal liability. For most crimes, it's not enough that you did the act. You also have to have intended it, or at least been reckless or negligent. If you run someone over with your car, the legal consequences depend on your mens rea. Did you do it on purpose? That's murder. Did you do it while drunk? That's vehicular manslaughter, a lesser crime, but still serious because you were reckless. Did you do it because your brakes failed and you didn't know they were faulty? That might not be a crime at all. The actus reus, is the same in all three scenarios. Someone died, but the mens rea is different, and that changes everything. Roman jurists developed this concept. They understood that moral culpability requires more than just causation. It requires a wrongful state of mind, and modern criminal law has refined this endlessly. We have degrees of intent, purpose, knowledge, recklessness, negligence, strict liability where mens rea isn't required. But the foundation, the idea that intent matters, is Roman. Actus reus, guilty act, the physical component of a crime. You have to actually do something, or fail to do something you're legally required to do. Thoughts alone aren't crimes. You can hate someone, fantasize about harming them, wish them ill. None of that is criminal. But if you act on it, if you translate thought into action, then the law intervenes. There are exceptions. Conspiracy, for example, is essentially an agreement to commit a crime. You can be prosecuted even if the crime never happens. But even then, there has to be some overt act in furtherance of the conspiracy. Some action, however small, that moves from thought to reality. The Romans understood this distinction. Intentions matter, but actions matter more. In loco parentes, in the place of a parent. It refers to someone acting with parental authority, even though they're not the legal parent. Teachers, school administrators, they're in loco parentis while kids are at school. They have authority to discipline, to make certain decisions, to protect the children. It's a delegation of parental responsibility. The concept comes from Roman law, where guardianship was a well-developed legal institution. Not all kids lived with their biological parents. Orphans, kids whose parents were away, kids given to relatives to raise. Someone had to have legal authority. The Romans called this tutela guardianship, and the guardian had many of the same powers as a parent. Modern in loco parentis is a descendant of this idea. Caveat emptor. Let the buyer beware. It's an old principle of commercial law. When you buy something, it's your responsibility to inspect it, to make sure it's what you want. If you buy a horse and it turns out to be lame, that's your problem. You should have checked. This sounds harsh, and modern consumer protection laws have modified it significantly. Now, sellers have duties. They can't lie about the product. They can't conceal defects. There are implied warranties in many transactions. But caveat emptor is still the starting point. You're expected to look out for your own interests. Don't just trust.
Verify.
The Romans applied this principle widely. Buyer beware. Seller isn't responsible unless they actively deceive you. Over time, this has been balanced with duties of good faith, with implied warranties, with consumer protection. But the underlying idea remains: you're responsible for your own decisions. The law will protect you from fraud, but not from your own carelessness. Res ipsa loquitur. The thing speaks for itself. It's a doctrine in tort law. Normally, if you're suing someone for negligence, you have to prove they were negligent. You have to show what they did wrong. But sometimes the accident itself is evidence of negligence. If a barrel falls out of a warehouse window and hits you, you don't need to prove the warehouse owner was negligent. The fact that the barrel fell is enough. Barrels don't just fall. Someone must have been careless. It's a rule of inference. The accident implies negligence. The thing speaks for itself. The phrase is Latin, and the doctrine has roots in Roman ideas about proof and presumption. Sometimes the facts are so clear that lengthy explanations are unnecessary. Stare decisis. To stand by things decided, this is a cornerstone of common law systems. Courts should follow precedent. If a higher court has decided a legal question, lower courts should apply that decision to similar cases. This creates consistency. Predictability. People can know what the law is because courts don't just make it up each time. The phrase is Latin, though the doctrine developed primarily in English courts. But the idea that past decisions should guide future ones has Roman roots. Roman jurists cited earlier opinions. They built on each other's work. They created a body of law that accumulated over time. That's the ancestor of stare decisis. Even in civil law countries, which don't follow precedent as strictly, judicial decisions still matter. They're not binding, but they're persuasive. Judges look at what other judges have said. They try to be consistent. The specific mechanism is different, but the underlying value that the law should be stable and predictable is the same. Then there are the maxims, short, pithy statements of legal principle. The Romans loved these, and many are still quoted today. Ignorantia legis neminem excusat. Ignorance of the law excuses no one. You can't break the law and then say, I didn't know. The law presumes you know it. That's a fiction, obviously. Nobody knows all the laws. There are thousands of them, but it's a necessary fiction. Otherwise, everyone would claim ignorance. Nemo iudex in causa sua. No one should be a judge in their own case. You can't be impartial if you have a personal interest. This is the foundation of recusal rules. If a judge has a conflict of interest, they have to step aside. Someone else has to decide. Audi alterum partem, hear the other side. Both parties should have a chance to be heard. You can't make a decision based only on one side's story. This is fundamental to due process. Fairness requires listening to both sides. Ubi ius, ibi remedium. Where there's a right, there's a remedy. If the law gives you a right, it has to provide a way to enforce it. Otherwise, the right is meaningless. This principle underlies much of civil procedure. Courts exist to provide remedies for violations of rights. Volenti non fit iuria. To a willing person, no injury is done. If you consent to something, you can't complain about it later. This is a defense in tort law. If you agree to participate in a boxing match, you can't sue your opponent for hitting you. You consented to the risk. These maxims aren't just clever sayings. They're distillations of legal principles refined over centuries. They're shorthand for complex ideas. And they're Latin because that's the language in which they were originally formulated by Roman jurists 2,000 years ago. So why does all this Latin persist? Why hasn't it been replaced with plain English, or whatever the local language is? Partly, it's tradition. Law is conservative. It values continuity. Changing terminology risks confusion. If you stop saying habeas corpus and start saying writ of bodily freedom or something, does that change the meaning? Do all the old cases still apply? It's safer to keep the traditional terms. Partly, it's precision. As we've discussed, Latin legal terms have specific meanings honed over centuries. They're technical vocabulary. Replacing them with ordinary language might introduce ambiguity. Partly, it's international. Latin is a neutral language. It doesn't belong to any modern nation. A lawyer in France and a lawyer in Brazil can both use Latin terms and understand each other, even if they don't speak each other's languages. It's a common legal lingua franca, and partly its identity. Lawyers are a profession. They have specialized knowledge. The Latin vocabulary is part of that. It signals expertise. It creates a boundary between insiders and outsiders. That can be elitist, sure. It can make law less accessible to ordinary people. But it also maintains standards. It ensures that people who practice law have been properly trained. There's a movement in many countries toward plain language in law, to write statutes, regulations, and court documents in clear, simple terms that ordinary people can understand. And that's good. Law should be accessible. But even plain language advocates recognize that some technical terms are necessary, and many of those terms are Latin, because they're so embedded in the system, so tied to specific concepts, that replacing them would be more confusing than helpful. So the language of ancient Rome lives on, not in the streets, not in homes or schools or most workplaces, but in courtrooms, in law offices, in legal documents, in the places where society's rules are written, interpreted, and enforced. Every time a lawyer says objection, res ipsa loquitur, or your honour, we move to quash this subpoena on the grounds of privilege, they're speaking a language that's been dead for conversational purposes for over a millennium. But it's not really dead. It's alive, thriving, evolving even, because Latin legal language isn't about the past. It's about the present. It's a living tool used to solve modern problems. And that's the thing about language. It doesn't have to be spoken in the streets to be alive. It just has to be used. To do work. To communicate ideas. And Latin does that every single day in courts around the world. So the next time you're watching a legal drama on TV, or reading a news article about a court case, or even just scrolling past some legal jargon online, pay attention. Notice the Latin. Notice how much of it there is. How casually it's used. How essential it is. Because you're hearing the voice of Rome, still speaking, still shaping the world, still teaching us how to think about justice. 2,000 years after the fall of the empire, the language endures, not in its full glory, not in poetry or oratory or everyday conversation, but in law, where it never stopped being useful, where it never stopped being necessary. Let's talk about something you probably take for granted. Your rights. The idea that you have them, that they're yours, that the government can't just take them away on a whim, that even if you're accused of a crime, you get a trial, you get to defend yourself. You're innocent until proven guilty. Where does this come from? Why do we believe this? It's not obvious. For most of human history, most people had no rights, not in any meaningful sense. You had whatever your king or lord or tribe decided you could have, and they could change their minds. There was no higher authority to appeal to. No written rules, no guarantees. Rome changed this. Not completely, not perfectly, not for everyone, but they planted seeds. Ideas that would grow slowly over centuries into the concepts of rights and citizenship we have today. Let's start with citizenship itself. What does it mean to be a citizen? Today, it usually means you belong to a nation. You have a passport. You can vote, at least in democracies. You have certain rights and protections, and you have obligations too. Pay taxes, obey laws, maybe serve in the military. But citizenship as a legal concept, as something that grants you specific rights and protections, that's Roman. Before Rome, most societies had subjects, not citizens. You belonged to a king or a city or a tribe. You owed loyalty and obedience, but you didn't necessarily have rights. Citizenship implies a reciprocal relationship. The state has obligations to you, not just you to the state. Roman citizenship was a big deal. It wasn't automatic. Not everyone living in Roman territory was a citizen. Originally, only people from the city of Rome itself were citizens. Everyone else was a foreigner, subject to different laws with fewer protections. But as Rome expanded, citizenship expanded too. It was granted to allies, to to freed slaves, though with some limitations, to entire communities that proved loyal, and eventually, in 212 CE, the Emperor Caracalla granted citizenship to almost everyone in the empire. This was partly pragmatic, it increased tax revenue, but it was also revolutionary. Suddenly, millions of people across Europe, North Africa, and the Middle East were Roman citizens. What did that mean? It meant you had legal protections. You couldn't be executed without a trial. You couldn't be tortured, at least not legally. You had the right to appeal. If you were accused of a crime, you could demand to be tried in Rome itself before the emperor if necessary. The Apostle Paul did this. He was a Roman citizen, born in Tarsus, and when he was arrested in Jerusalem, he invoked his citizenship. "I appeal to Caesar," he said, and they had to send him to Rome. This is remarkable. The idea that your status as a citizen gives you rights that even the authorities have to respect. That there are procedures, rules, limits on what the state can do to you. That's the foundation of the rule of law. The rule of law. It's a phrase we throw around, but what does it actually mean? It means the law is supreme. Above everyone. Above kings. Above presidents. Above the rich and powerful. No one is above the law. Everyone is subject to it. And the law itself is written, knowable, and applied consistently. This is a Roman idea. Or at least, the Romans articulated it in a way that stuck. The concept exists in other cultures too, but Rome formalized it. They wrote it down. They built institutions around it. In the Roman Republic, even the consuls, the highest officials, were bound by law. They couldn't just do whatever they wanted. There were procedures, checks. The Senate, the assemblies, other magistrates. If a consul exceeded his authority, he could be prosecuted after his term ended. This didn't always work. Powerful men often got away with things. But the principle was there. The law applied to everyone. The emperors complicated this. They had enormous power. But even they, at least in theory, ruled according to law. The emperor's word was law, yes. But it was law. It was written down. It could be studied. Challenged even, though that was dangerous. And future emperors were bound by the laws of past emperors, unless they explicitly changed them. Compare this to other systems. A Persian king's word was absolute. What he said one day, he could contradict the next. There was no appeal, no higher authority. The king was the law. In Rome, the law existed independently. Even the emperor was, in a sense, its servant. He enforced it, interpreted it, added to it, but he didn't replace it. This distinction matters. It's the difference between arbitrary rule and legal rule, between tyranny and governance. And it's a cornerstone of modern democracy. Every constitution in the world is built on this idea that there are fundamental rules, written rules, and even the government has to follow them. If the government violates the constitution, courts can strike down its actions. The law is supreme, not the people in power, but the law itself. This concept, constitutional government, limited government, the rule of law, it all traces back to Roman legal thought, to the idea that law is something external, rational, and binding on everyone. Now let's talk about equality before the law. This is tricky, because the Romans didn't believe in equality the way we do. They had a rigid social hierarchy, patricians and plebeians, citizens and non-citizens, free people and slaves. And the law treated these groups differently. But here's the thing. Within each category, the law was supposed to apply equally. All citizens had the same rights. One citizen couldn't be treated worse than another just because of personal dislike or political rivalry. There were rules, procedures, and they applied to everyone in the same category. This is the seed of legal equality, the idea that the law doesn't play favourites, that it's impartial, neutral, blind, as the famous metaphor goes. Lady Justice wears a blindfold. She doesn't see who you are. She only sees what you did. Obviously, the Romans didn't live up to this ideal. Wealth and connections mattered. Corruption existed. But the ideal was there, written down, argued about, and over time the categories expanded. more people became citizens. Slavery was eventually abolished. Women gained rights. The circle of who counted as equal under the law grew wider. Modern legal systems have taken this much further. Equality before the law is now a fundamental principle. Most constitutions guarantee it. The 14th Amendment to the U.S. Constitution. No state shall deny to any person within its jurisdiction the equal protection of the laws. That's legal equality, and it's a direct descendant of Roman thought. Let's talk about due process. This is the idea that you can't be punished without a fair procedure, that you have a right to know the charges against you, to confront your accusers, to present a defense, to have a decision made by a neutral judge based on evidence and law, not on whim or prejudice. The Romans developed these concepts. They had formal trials, rules of evidence, rights of the accused. Not in every case, not always fairly, but the structure was there. If you were accused of a crime, you had the right to a hearing. The accuser had to present evidence. You could respond. You could bring witnesses. You could hire an advocate, a lawyer, to argue for you. The judge or a jury of your peers in some cases would weigh the evidence and make a decision. This is due process, the procedural protections that stand between you and state power. And it's enshrined in modern law. The Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. That phrase, due process, comes from English common law. But the concept, the idea behind it, is Roman. The Romans also developed the presumption of innocence, the idea that you're not guilty just because you're accused. The burden of proof is on the accuser. They have to prove you did it. You don't have to prove you didn't. This seems obvious now, but it's not. In many historical legal systems, accusation was enough. If someone accused you, you were presumed guilty unless you could prove otherwise. Sometimes through trial by ordeal, stick your hand in boiling water. If it heals, you're innocent. If it doesn't, you're guilty. That's not justice. That's torture. The Romans were better. Not perfect. They used torture too, especially on slaves. But for citizens, there was a presumption of innocence. The state had to make its case. And if the evidence was insufficient, you were acquitted. This principle is fundamental to modern criminal law. Innocent until proven guilty. It's in the Universal Declaration of Human Rights. It's in national constitutions. It's taught to law students in their first year. And it's Roman. Now let's talk about proportionality. The idea that punishment should fit the crime. You don't execute someone for jaywalking. You don't fine someone $5 for murder. There should be some rational relationship between the offence and the penalty. The Romans understood this. Their legal system had gradations of punishment. Minor offences got minor penalties, fines, public shaming. More serious offences got harsher penalties, exile, imprisonment, execution. And the method of execution varied depending on the crime and the status of the criminal. Citizens were usually beheaded, a quick death. Non-citizens might be crucified, a slow, agonizing death. It was brutal, but it was systematic. There were rules. Modern law has refined this enormously. We don't crucify people anymore, thankfully. But the principle of proportionality remains. The Eighth Amendment prohibits cruel and unusual punishment. International human rights law requires that penalties be proportionate. Sentencing guidelines try to ensure consistency. The idea is the same. Punishment should be rational, measured, appropriate to the offence. The Romans also pioneered the concept of mitigating circumstances. The idea that context matters. If you kill someone in self-defense, that's different from premeditated murder. If you steal because you're starving, that's different from stealing for profit. The act might be the same, but the circumstances change the moral calculus. Roman judges had discretion. They could consider the defendant's character, their motives, the context of the offence. They could adjust penalties accordingly. This idea persists. Modern judges consider mitigating and aggravating factors at sentencing. Prior criminal history, the defendant's age, whether they showed remorse, Whether the victim was particularly vulnerable, all of this affects the outcome. It's an acknowledgement that justice isn't mechanical. You can't just apply rules without thinking. You have to look at the whole situation. The Romans understood this. They built flexibility into their system. Let's shift to property rights. The idea that you can own things, that ownership means something, that the state will protect your property from theft or seizure. This seems basic, but it's not universal. In many societies, property was communal, or it belonged to the king. The idea of individual ownership with legal protections is relatively modern, and it's Roman. The Romans developed a sophisticated system of property law. They defined ownership precisely. They created rules for how property is acquired, transferred, and inherited. They protected property rights through legal action. If someone stole from you, you could sue. If someone damaged your property, you could demand compensation. This created economic stability. People were willing to invest, to build, to accumulate wealth because they knew the law would protect it. This is one of the foundations of market economies. Without secure property rights, commerce breaks down. Nobody trades, nobody builds, nobody invests, because everything can be taken at any moment. Modern economies depend on this. Every business, every homeowner, every investor, they all rely on the legal system to protect their property. And that system, the structure of property law, the concepts and categories, is Roman. The same goes for contract law. The idea that agreements are binding, that if you promise to do something, the law will hold you to it. This enables complex economic activity, long-distance trade, credit, partnerships. None of it works without enforceable contracts. The Romans understood this. They created a whole body of contract law, rules about what makes a valid contract, what remedies exist if someone breaches, how to interpret ambiguous terms. And it's all still there in modern law, refined but recognizable. So when we talk about Roman influence on modern legal systems, we're not just talking about obscure principles or fancy Latin phrases. We're talking about the basic architecture of how societies function, how disputes are resolved, how property is protected, how agreements are enforced, how rights are defined and defended. It's the infrastructure of civilization. And it's Roman. You probably didn't wake up this morning thinking about the 12 tables or Justinian's code. You probably just went about your day. But every interaction you had with the legal system, every assumption you made about your rights, every expectation you had about how society should work, was shaped by ideas that originated in ancient Rome. You live in a world built on Roman law. Even if you've never heard of it, even if you don't care, even if this is the first time you've thought about it, it's there, in the background, holding everything together, making sure the lights stay on and the trains run on time, metaphorically speaking. And here's the wild part. It works. Not perfectly. No system does. There are injustices, corruption, mistakes. But compared to the alternatives, compared to societies without the rule of law, without rights, without legal protections, it's pretty good. You can own property and reasonably expect to keep it. You can make agreements and reasonably expect they'll be honoured. You can be accused of a crime and reasonably expect a fair trial. None of this is guaranteed. All of it can fail. But the framework exists. And that framework is Roman. So the next time you hear someone complain about lawyers or bureaucracy or the legal system being slow and complicated, remember this. It's slow and complicated because it's trying to be fair, to give everyone a chance, to follow rules instead of impulses, to apply the law consistently instead of arbitrarily. That's the Roman legacy. Not conquest, not empire, not gladiators or aqueducts or roads. Those are impressive, sure, but they crumbled. They're ruins now. Tourists take pictures. The law didn't crumble. It evolved. It spread. It became the foundation for how billions of people live their lives. It's not perfect, but it's persistent. And it's Roman. 2,000 years after the fall of the Western Empire, the legal principles Rome developed still govern the world, still protect rights, still resolve disputes, still uphold the idea that society should be governed by rules, not by the whims of the powerful. And that's not nothing. That's civilization. Fragile, imperfect, constantly threatened, but still standing, still working, still Roman. Let's talk about something more intimate.
Your family.
Your home, your personal relationships. The law reaches here too, into your living room, into your bedroom, into the most private corners of your life. And when it does, when it defines who counts as family, who gets to inherit your stuff, who has authority over children, it's often speaking with a Roman accent. Family law feels modern, contemporary. It's about marriage equality, custody battles, divorce settlements, prenuptial agreements, things that seem very much of our time. But dig a little deeper and you find Roman bones beneath the modern flesh. Start with marriage itself. What is it, legally? In most legal systems, marriage is a contract. A special kind of contract, sure, one with social and often religious significance. But at its legal core, it's an agreement between two people that create specific rights and obligations. Property rights, inheritance rights, decision-making rights, obligations of support. This contractual understanding of marriage comes from Rome. The Romans were pragmatic about marriage. It wasn't primarily about romance or religion. It was about alliance, about property, about producing legitimate heirs. Love was nice if it happened, but it wasn't the point. Roman marriage required consent. Both parties had to agree. That was revolutionary for the ancient world, where marriages were often arranged without the woman's input. In Rome, at least legally, she had to say yes. Not that social pressure didn't exist. Not that families didn't exert enormous influence. But the principle was there. Marriage required the consent of both parties. This idea persists. Modern marriage law requires consent. You can't force someone to marry you. You can't marry someone who's unconscious or mentally incapacitated. Both parties have to understand what they're agreeing to and actually agree to it. That's Roman. The Romans also understood marriage as creating a legal partnership. Spouses had obligations to each other. Support, fidelity, at least in theory, mutual respect. And they had joint interests in property, though the details varied over time and depended on what type of marriage they entered into. There were different forms of Roman marriage. Cum manu, where the wife passed from her father's authority to her husband's. She became part of his family legally. And sine manu, where she remained under her father's authority, or if he was dead, became legally independent. This second form gave women more autonomy. They could own property separately, manage their own affairs. It became increasingly common over time. Modern marriage law has evolved far beyond this. We've abolished the idea of women being under male authority. We've recognized marriage equality, that same-sex couples have the same rights as opposite-sex couples. We've expanded the rights of married partners and created protections for domestic partnerships and other relationship forms. But the basic structure, marriage as a legal contract that creates mutual rights and obligations, that's Roman. And the idea that spouses should have some autonomy, that marriage doesn't mean one person becomes the property of the other, that evolved from Roman principles. Now, divorce. The Romans were surprisingly relaxed about this. Compared to later Christian European societies, where divorce was nearly impossible, Roman divorce was straightforward. Either party could initiate it. You didn't need a reason. You didn't need permission from a court or a priest. You just declared the marriage over, and it was over. Of course, there were complications. Property had to be divided. Dowries had to be returned. Children's custody had to be determined. But the basic act of divorce was simple. This was controversial even in Rome. Some moralists complained that it made marriage too easy to exit, that it undermined family stability. But legally, it remained relatively accessible. After Rome fell, Christian doctrine took over in Europe. Divorce became almost impossible. Marriage was a sacrament, indissoluble except in rare circumstances. This persisted for over 1,000 years. Only in the last century or two have most Western countries returned to something more like the Roman approach. No-fault divorce, the recognition that sometimes marriages don't work and people should be able to leave. So modern divorce law, in its accessibility and its pragmatism, is actually more Roman than medieval. It's a return to an older, more flexible system. Funny how that works. Then there's children. Roman law about children was harsh. The paterfamilias, the male head of the household, had enormous power. Technically, he had the power of life and death over his children. He could reject a newborn, expose it to die. He could sell children into slavery. He could punish them however he wanted. In practice, these extreme powers were rarely used. Social norms constrained them. Fathers who abused their authority faced social censure. And by the later empire, the law itself began limiting paternal power. Infanticide was outlawed. Selling freeborn children was restricted. The absolute power of the father was gradually eroded. But the concept of parental authority persisted. Parents have rights over their children. They make decisions about education, religion, medical care. They control the child's property. They represent the child legally. This is still true today. Parental rights are a fundamental part of family law. And they trace back to Roman concepts, though thankfully without the extremes. Modern law balances parental rights with the rights and welfare of the child. We recognize that children are persons with their own interests, not just property of their parents. If parents abuse or neglect their children, the state can intervene. Parental authority isn't absolute, but it's still significant. And the legal category, parental authority, is Roman. Adoption is another Roman innovation, or at least the Romans formalized it legally. Adoption existed in other cultures, but the Romans made it a full legal process. An adopted child became a legitimate member of the adoptive family. They took the family name. They had inheritance rights. They were, legally, no different from biological children. This was often used politically. Emperors adopted their successors. Wealthy men without sons adopted heirs. It was a way to continue a family line, to pass on property and status. But it also benefited the adoptees. They gained family, status, security. Modern adoption law is much more focused on the child's welfare. We don't adopt adults for political purposes, usually, but the basic legal structure, adoption as creating a full parent-child relationship with all the attendant rights and obligations, that's Roman. Now let's talk about inheritance. This is where Roman influence is especially strong. The Romans were obsessed with inheritance. Who gets what when you die? It mattered enormously in a society where property meant everything. Before Rome, inheritance was usually customary. The eldest son gets everything. Or it's divided among all sons. Or the tribe decides. There were traditions, but not necessarily written laws. The Romans systematized it. They created detailed rules about interstate succession, what happens if you die without a will. They prioritized family members in a specific order. Descendants first. Then ascendants, parents and grandparents. Then siblings, then more distant relatives. These rules made sense. They reflected social values. Family takes care of family. Your property should stay in the bloodline. And they created predictability. You knew what would happen to your property if you died suddenly. But the Romans also created something more flexible, the will. A legal document where you could specify exactly who gets what. You could leave property to your children, but you could also leave it to friends, to freedmen, to institutions. You had testamentary freedom, the right to decide. There were limits. You couldn't completely disinherit your children without good reason. They had a right to a portion of your estate, the legitima. This protected families, prevented disinherited children from becoming destitute. But within those limits, you had wide discretion. This system spread everywhere. Today, almost every legal system has interstate succession rules for people who die without a will, and the order of priority is usually similar to Rome. Spouse and children first, then parents, then siblings, then more distant relatives. It varies by jurisdiction, but the basic structure is Roman, and wills are universal. You can write a will specifying who gets your property. There are formalities, witnesses, sometimes notarization, rules about mental capacity. You have to understand what you're doing. Rules about undue influence. Nobody can coerce you into writing a particular will, but the concept testamentary freedom within limits is Roman. The Romans even developed the concept of trusts, sort of. They had fideicomissum, a request to an heir to pass property to someone else. It wasn't legally binding at first, just a matter of honor. But over time, it became enforceable. You could require your heir to hold property for the benefit of someone else. This evolved into the modern trust, a legal arrangement where one person holds property for the benefit of another. Trusts are huge in modern law: estate planning, asset protection, charitable foundations, all built on the Roman idea that you can separate ownership from benefit, that you can impose conditions on how property is used after you're gone. Then there's guardianship. What happens to children whose parents die? Or to adults who become incapacitated? Someone has to have legal authority to make decisions for them. The Romans called this tutela for children and cura for incapacitated adults. The guardian had broad powers. They managed the ward's property, made decisions about education, marriage, daily life. But they also had responsibilities. They had to act in the ward's interest. They could be held accountable if they mismanaged the property or abused their authority. Modern guardianship law works the same way. If you're a minor and your parents die, a court appoints a guardian. If you develop dementia and can't manage your affairs, a court can appoint a conservator or guardian. These people have authority, but they're supposed to act in your interest. And they can be supervised by the court. The legal structure, the categories, the balance between authority and accountability, it's all Roman. Let's talk about something darker: domestic violence, abuse. For much of history, what happened in the home stayed in the home. A man's home was his castle. He could do what he wanted to his wife and children. The law didn't intervene. But that's not entirely true. Even in Rome, where patriarchal authority was strong, there were limits. Excessive cruelty was criticized. A husband who killed his wife could be prosecuted. It wasn't common. Social norms protected abusers more than victims. But the principle existed that some acts, even within the family, were crimes. Modern law has expanded this enormously. Domestic violence is a crime. Spousal abuse, child abuse, elder abuse. The law intervenes. Protective orders, criminal prosecution, removal of children from dangerous homes. We recognize that the family isn't a law-free zone, that rights exist even within intimate relationships. This is a departure from medieval and early modern European law, which gave husbands almost unlimited authority. But it's a return to something closer to the Roman approach. The recognition that family relationships are subject to law, that there are limits, that the state has an interest in protecting vulnerable members of society. The specifics are different. Our protections are much stronger. Our understanding of rights is much broader. But the basic idea that family relationships are legally regulated, that the law sets boundaries on behavior even in private, that's Roman. Now, let's talk about legitimacy. This is a concept that mattered enormously in Roman society and continued to matter for centuries. Legitimate children born to married parents had full rights. Illegitimate children born outside marriage had limited rights. They couldn't inherit from their father. They didn't belong to his family legally. They were disadvantaged from birth. This seems cruel now. We recognize that children shouldn't be punished for circumstances beyond their control. Most modern legal systems have abolished or reduced the legal disabilities of illegitimate children. Children born outside marriage have the same rights as those born within it, at least in most respects, but the concept of legitimacy still exists. It's relevant in inheritance, in citizenship, in determining parental rights. We've softened the edges, we've made it less punitive, but the category persists. And it's Roman. The Romans also dealt with something that seems very modern: blended families, remarriage, step-parents, stepchildren. How do these relationships work legally? The Romans had rules about this. A step-parent didn't automatically have authority over stepchildren. Those children remained under their biological father's authority. But the step-parent had some obligations, some responsibilities. The lines were complex. Modern family law struggles with the same issues. When parents divorce and remarry, when children live in households with step-parents and step-siblings, who has authority? Who has obligations? The law tries to answer these questions. And it's hard because family structures don't fit neat categories. The Romans understood this. They created flexible rules, case-by-case determinations. Recognition that family is complicated, that law has to adapt to reality. We're still doing the same thing. Still trying to balance competing interests. Still trying to protect children while respecting parental rights. Still working with Roman concepts, even if we don't realize it. Here's the thing about family law. It's deeply personal. It affects the most intimate parts of your life. Your relationships, your children, your home, your death. And it's also deeply Roman. The categories, the structures, the way we think about these relationships legally. It's all shaped by principles developed 2,000 years ago. You might get married someday, if you haven't already. When you do, you're entering a legal contract structured by Roman ideas. You might have children. Your parental authority over them is defined by Roman concepts. You might write a will. You're exercising Roman testamentary freedom. You might get divorced. The process, however painful, follows Roman logic. All of this feels modern because the details are modern. The language is different. The values have evolved. We've expanded rights, abolished discriminatory rules, recognized new family forms. But the skeleton, the legal architecture that supports it all, is ancient. Roman. And most people never think about it. They just live their lives, get married, have kids, write wills, go through divorces. They interact with family law constantly, but they don't wonder where it came from. They assume it's just how things are, but it's not natural. It's not inevitable. It's the product of centuries of legal development. And the starting point, the foundation it's all built on, is Rome. So the next time you go to a wedding, or sign custody papers, or read a will, or even just think about who should inherit your stuff when you die, remember, you're participating in a legal tradition older than most religions, older than most languages, older than the concept of the nation-state. You're part of something vast, something that stretches back through centuries, through empires and kingdoms, through wars and plagues and revolutions, something that survived all of it. Roman family law, still shaping families, still governing the most personal aspects of our lives, still there, quietly, in the background, doing its work, because families change, society changes, technology changes, but the need for legal structures to govern relationships, to protect the vulnerable, to provide certainty and predictability, that doesn't change. That's constant, and Rome figured it out. Not perfectly, not finally. Law is never finished. It's always evolving. But Rome created the template, the framework, the vocabulary, and we're still using it every single day, in every family, in every home, everywhere. Close your eyes for a second. Imagine you're accused of something. Doesn't matter what. Theft, assault, treason, whatever. You're dragged before a tribunal. No trial, no evidence, no chance to speak. Just a verdict. Guilty. Punishment is swift. Final, brutal. How does that feel? Wrong, right? Deeply, fundamentally wrong. Not just unfortunate, not just unfair in a practical sense, but wrong in a moral sense, a violation of something essential, something that transcends the specific laws of your country or the whims of whoever's in charge. That feeling, that instinct that there are some things that are just wrong, regardless of what any law says, that's natural law thinking. And it's Roman. The Romans didn't invent morality. Obviously, every society has moral codes, rules about right and wrong, But the Romans, or at least Roman legal philosophers, did something distinctive. They separated law into categories. There was jus civile, civil law, the specific rules that applied to Roman citizens. There was ius gentium, the law of nations, rules used in dealing with foreigners. And then there was ius naturale, natural law. Natural law was different. It wasn't created by the Senate or decreed by an emperor. It wasn't specific to Rome or to any particular society. It was universal, derived from nature itself, from reason, from the fundamental order of the cosmos. It was law that existed whether humans recognized it or not. This is a big idea, maybe one of the biggest ideas Rome ever produced, because it implies that human laws, the rules we make, aren't arbitrary. They're not just whatever the powerful decide. They're supposed to reflect something deeper, something true. And if they don't, if they violate natural law, then they're not really law at all. They're just commands backed by force. The Roman jurist Cicero wrote about this in the 1st century BCE. He said that true law is right reason in agreement with nature. It's universal, unchanging, eternal. It applies to all people in all times, and it can't be altered by human legislation. You can pass a law saying murder is legal, but that doesn't make murder right. Natural law says it's wrong, and no human decree can change that. This was radical. Most ancient legal systems were positivist, even if they didn't use that term. Law was whatever the king or the assembly or the priests said it was. There was no higher standard, no appeal beyond human authority. Cicero said no, there is a higher standard, and human laws are judged against it. Now, the Romans didn't always follow this principle. They did plenty of things that violated natural law as they understood it. Slavery, conquest, oppression. The gap between theory and practice was enormous. But the theory existed. It was written down. It was taught. And it survived. When Christianity spread through the Roman Empire, it absorbed this concept. Christian theologians loved natural law. It fit perfectly with their worldview. God created the universe. He built moral laws into its very structure. Natural law was God's law, written on the human heart, accessible through reason. St. Augustine wrote about it. St. Thomas Aquinas developed it into a comprehensive system in the 13th century. He said there are 4 types of law. Eternal law, God's plan for the universe. Natural law, the part of eternal law that humans can understand through reason. Divine law, revealed in Scripture. And human law, the specific rules created by governments. Human law is only legitimate if it conforms to natural law. If it doesn't, it's not law. It's corruption. This idea shaped medieval and early modern European thought. It was the framework for thinking about justice, about rights, about the limits of government power, and it was fundamentally Roman in origin, even if it was dressed up in Christian theology. Fast forward to the Enlightenment, the 17th and 18th centuries. Thinkers like John Locke, Jean-Jacques Rousseau, Immanuel Kant, they secularized natural law, stripped away the explicitly religious elements, but kept the core idea that there are universal moral principles, that humans have inherent rights not granted by governments but existing prior to them, that the purpose of government is to protect these rights. Locke talked about natural rights to life, liberty, and property. He said people create governments to secure these rights, and if a government fails to do so, if it becomes tyrannical, people have the right to overthrow it. This is natural law theory. The government's legitimacy depends on whether it respects fundamental moral principles. These ideas fueled revolutions. The American Revolution, the French Revolution, the entire concept of a constitution, a written document that limits government power and protects individual rights, is based on natural law thinking. The government can't do whatever it wants. It's bound by higher principles, and those principles are written down, made explicit, enforceable. The US Declaration of Independence is a natural law document. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. self-evident, not granted by the king, not created by parliament. They just are. They exist, and governments exist to secure them. That's Roman natural law, filtered through centuries of Christian theology and Enlightenment philosophy. But the root is Roman. The idea that there's a higher law, that human rights are real and universal, that governments are judged by whether they respect fundamental moral principles. Now let's jump to the 20th century, 2 world wars, the Holocaust, genocides, totalitarian regimes, unimaginable atrocities, and in the aftermath, the international community tries to build something better, a framework to prevent it from happening again. And what do they reach for? Natural law. The Universal Declaration of Human Rights, adopted by the United Nations in 1948, is a natural law document. It asserts that all human beings have inherent dignity and rights, not because any government grants them, but because they're human. The rights exist. The Declaration just recognizes them. Article 1. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood, born free, endowed with rights. Not given rights, not granted rights, endowed. They're inherent. Natural. The document goes on to list specific rights. The right to life, to liberty, to security of person, to be free from slavery and torture, to equality before the law, to a fair trial, to freedom of thought, conscience and religion, to freedom of expression, to participate in government, to work, to education, to an adequate standard of living. These aren't just nice ideas. They're presented as universal moral truths. They apply to everyone, everywhere, regardless of culture or government, and governments are supposed to respect them. If they don't, the international community can, at least in theory, intervene. This is natural law. The idea that there are moral principles that transcend national boundaries, that bind all governments, that protect all people. It's Roman, dressed in 20th century language, backed by international institutions. And it's not just the Universal Declaration. There are international treaties, conventions, covenants, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention Against Torture, the Convention on the Rights of the Child, all of them based on the premise that certain rights are universal and inalienable. National constitutions around the world have adopted this framework. After World War II, when countries wrote new constitutions, they included bills of rights. Lists of fundamental freedoms that the government can't violate. Germany, Japan, Italy. Later, when colonies gained independence, they wrote constitutions with rights protections. When authoritarian regimes fell and democracies emerged, same thing. South Africa, Eastern Europe, Latin America. Even countries that don't fully respect these rights in practice, and there are many, still acknowledge them rhetorically. They sign treaties. They write rights into their constitutions. They pay lip service, because the international consensus, at least officially, is that these rights exist, that they matter, that governments are supposed to protect them. And all of this, the entire human rights framework that we take for granted, traces back to Roman natural law, to the idea that justice isn't arbitrary, that there are moral truths. That law should reflect them. Now let's be clear, natural law isn't without problems. Who decides what natural law is? Different people, different cultures, different eras have had different ideas about what's natural and what's right. The Romans thought slavery was natural. Medieval Christians thought heresy should be punished by death. Enlightenment thinkers thought only property-owning men should have political rights. Natural law can be used to justify all sorts of things. It can be conservative, defending existing hierarchies as natural and ordained, or it can be radical, calling for the overthrow of unjust systems in the name of higher principles. It's flexible, malleable, and that makes it both powerful and dangerous. Critics say natural law is just a way of dressing up your personal moral preferences in fancy language. You think something is right, so you call it natural law, and suddenly it's not just your opinion. It's a universal truth. It's a way of shutting down debate. This isn't just what I believe. It's what nature demands. It's what reason requires. Who can argue with that? And yet, despite these problems, despite the abuses and the ambiguities, despite the fact that natural law can be twisted to serve almost any agenda, the core idea persists, because it speaks to something real. The sense that some things are just wrong, that morality isn't just a matter of opinion, that there are limits to what governments can legitimately do. You can reject natural law as a philosophical theory. You can say there are no universal moral truths, that everything is relative, that law is just whatever society decides. But then you have to accept that the Holocaust wasn't objectively wrong. It was just against the law in some countries. That slavery wasn't objectively evil. It was just eventually prohibited. That torture, oppression, genocide, they're not inherently bad. They're just things some societies disapprove of. Most people can't accept that. Instinctively, we believe some things are wrong, regardless of what any law says. And that instinct, that moral sense, is what natural law theory tries to articulate. It's the foundation of human rights, of the idea that there are limits to state power, of the belief that individuals have dignity and worth that must be respected. And it's Roman, the philosophical framework, the vocabulary, the conceptual tools, they come from Rome, from Cicero and the Stoics, from Roman jurists trying to make sense of justice in a vast, diverse empire, trying to find principles that could apply to everyone, not just Romans, trying to articulate a law that transcended borders and cultures. They didn't succeed completely. They couldn't. The project is too ambitious, too idealistic, but they started it. They planted the seed. And that seed grew into the human rights movement, into international law, into the idea that all human beings, regardless of where they're born or what government rules them, have certain fundamental rights that must be respected. Every time a court strikes down a law as unconstitutional, every time an international tribunal prosecutes war crimes, every time activists invoke human rights to challenge oppression, they're drawing on natural law, on the idea that law isn't just power, that there are principles beyond the written code, that justice is real. And whether they know it or not, they're speaking Roman, using concepts developed 2,000 years ago, standing on foundations laid in the Forum, arguing in a tradition that stretches from Cicero to Aquinas to Locke to the framers of the Universal Declaration of Human Rights. The Romans weren't perfect, far from it. They violated their own principles constantly. But they articulated those principles. They wrote them down. They created a language for talking about justice that transcends particular times and places. And that language, that framework, is still in use. Because some ideas are too powerful to die, too useful to abandon, too true in some deep sense to be forgotten. Natural law is one of those ideas. The belief that there's a moral order to the universe, that humans can understand it through reason, that laws should conform to it, that when they don't, we have a right, maybe even a duty, to resist. It's idealistic, maybe naively so, but it's also hopeful. It says that might doesn't make right, that power isn't self-justifying, that there's something higher, something better, something we should aspire to. And that aspiration, however imperfectly realized, is part of what makes us human. It's also Roman, through and through, in its origins, in its logic, in its vocabulary, in its ambitions. The dream of a law that applies to everyone, that protects everyone, that holds everyone, even emperors and presidents and kings, accountable to standards they didn't create and can't change. That dream hasn't been realized. Maybe it can't be. But we're still chasing it, still trying. Still building legal systems that aim, however imperfectly, at justice, at rights, at dignity, at the protection of the vulnerable from the powerful. And every time we do, we're working in a Roman tradition, walking a Roman road, speaking a Roman language, pursuing a Roman dream. The marble halls have crumbled, the legions are gone. The emperors are dust, but the ideas endure. The principles persist. The dream survives, and maybe that's Rome's real legacy. Not the territory it conquered, not the buildings it erected, not even the laws it wrote, but the idea that law should be just, that justice is universal, that rights exist, that we can build systems to protect them, an idea that refuses to die. That adapts to new circumstances, that inspires new generations, that keeps getting reborn again and again in new forms, in new languages, in new movements, an idea that's still alive. Still fighting, still Roman. 2,000 years later, natural law still shapes how we think about justice, still provides the foundation for human rights, still limits what governments can do, still protects the weak from the strong, at least in theory, and that's not nothing. That's everything. That's the difference between civilization and barbarism, between a world governed by law and a world governed by violence, between a society that recognizes human dignity and one that tramples it. The Romans started us on that path. Not alone, not perfectly, but they started it, and we're still walking it, still arguing about what natural law requires, still debating what rights we have, still trying to build legal systems that reflect moral truths, still believing, despite all evidence to the contrary, that justice is possible. That's the Roman gift. Not certainty, but aspiration, the belief that law should be more than power, that it should be reason, morality, justice, and that belief, however battered, however challenged, however imperfectly realized, is still alive, still guiding us, still shaping the world, still Roman. Let's bring this forward, all the way forward, to right now, to today, to the world you actually live in, not the world of emperors and togas and Latin inscriptions on marble. You woke up this morning. Maybe you checked your phone, scrolled through news, saw something about a court case, a new law, a political scandal, an international dispute. You probably didn't think much of it, just the noise of the world turning. But underneath it all, beneath every headline, every legal dispute, every constitutional crisis, Roman law is there, quietly, invisibly, still doing its work. Let's start with something concrete. Your phone, that device in your pocket or on your nightstand. You bought it, right? Or maybe someone gave it to you. Either way, you own it. It's yours. And you know what that means. You can use it, sell it, give it away. Smash it with a hammer if you want, though that seems wasteful. Nobody can just take it from you. If someone steals it, that's a crime. If someone breaks it, they might owe you compensation. All of that, the entire concept of ownership, the rights it gives you, the protections you have, that's Roman property law. The categories, the logic, the remedies, 2,000 years old and still functioning perfectly. Or your apartment, your house. You rent or you own. If you rent, you have a lease. That's a contract. It gives you the right to occupy the property for a specified time at a specified price. The landlord can't just kick you out, not without cause, not without following legal procedures. You have rights, enforceable rights, and if the landlord violates them, you can sue. If you own, you have even more rights. You can modify the property, sell it, leave it to your kids. Nobody can take it without compensation, not even the government. There are limits, sure, zoning laws, building codes, taxes, but the core of ownership, the bundle of rights that comes with it, that's Roman. Dominium, the right to use, consume, destroy, and alienate. It's in the digest. It's in Justinian's code. And it's in your deed or your lease agreement. You probably work. Maybe you have an employment contract. Maybe it's formal, signed and notarized. Maybe it's informal, a handshake and a promise. Either way, it's a contract. You agree to provide labor. Your employer agrees to pay you. And if they don't pay, you can sue. You can take them to court. You can demand what you're owed. Because agreements create obligations. Pacta sunt servanda. Contracts must be kept. That's Roman. Maybe you've bought something online, clicked add to cart, entered your credit card information, clicked purchase. Congratulations. You just made a contract. Offer and acceptance. Consideration exchanged. The seller is obligated to deliver the product. You're obligated to pay. If they don't deliver, you can demand a refund. If the product is defective, you can return it. Consumer protection laws give you additional rights, but the foundation is contract law, Roman contract law. Or maybe you've been in a car accident. Someone ran a red light and hit you. Your car is damaged. Maybe you're injured. You can sue. You can demand compensation. Because the other driver was negligent. They had a duty to drive safely. They breached that duty. They caused harm. And they're liable. That's tort law. Lex Aquilia. Fault. Causation. Damages. Roman concepts applied to a situation the Romans never imagined, cars, but the logic is the same. Maybe you've written a will, or you should write one. Either way, the concept exists. You can decide who gets your property when you die. You have testamentary freedom. Within limits, you can't disinherit your spouse or minor children in many jurisdictions, but you have significant discretion. That's Roman. The will as a legal document, the idea that your wishes should control, the formalities required to make it valid, all Roman. Or maybe you've been called for jury duty. You sit in a courtroom. A judge presides. Lawyers argue. Evidence is presented. Witnesses testify. You, along with other jurors, decide the facts. The judge applies the law. It's an adversarial process. Two sides presenting their best case. A neutral arbiter making a decision based on evidence and law, not whim. That structure is Roman. The specific institution of the jury is English, but the adversarial trial structure, the rules of evidence, the burden of proof, those are Roman. Let's zoom out. Beyond your personal life, to the bigger picture. Governments, constitutions, international relations. Roman law is there too. Most countries have written constitutions. Documents that lay out the structure of government, the powers of different branches, the rights of citizens. The idea of a written constitution, of fundamental law that even the government must obey, traces back to Roman legal thought. The concept of lex fundamentalis, fundamental law that's superior to ordinary legislation. The Romans didn't have constitutions in the modern sense, but they had the idea that some laws were more fundamental than others, that some principles constrained even the sovereign. This idea developed over centuries. Medieval scholars, Enlightenment philosophers, revolutionary movements, but the seed is Roman. And today, almost every country has a constitution, a written document that's supreme. That can't be changed easily. That limits what the government can do. That protects rights. That provides a framework for governance. The structure of these constitutions varies. Presidential systems, parliamentary systems, federal systems, unitary systems. But the underlying concept, written fundamental law, is everywhere, and it's rooted in Roman legal tradition. Take separation of powers. The idea that government power should be divided among different branches so no single entity becomes too powerful. Executive, legislative, judicial, each with its own role, each checking the others. This is famously associated with Montesquieu, an 18th century French philosopher. But Montesquieu was drawing on Roman examples. The Roman Republic had magistrates, the Senate, and assemblies. Power was divided. Checks existed. It didn't always work, but the structure was there. Modern democracies have taken this much further. The US. Constitution explicitly divides power among three branches. Many other constitutions do the same. The specifics vary, but the principle is widespread. Don't concentrate power. Divide it. Create accountability. That's a Roman idea, refined over centuries. Or take judicial review. The power of courts to strike down laws that violate the Constitution. This is a powerful check on government authority. If the legislature passes an unconstitutional law, courts can invalidate it. The law is void. It has no effect. This specific power developed most fully in the United States, established in the case Marbury v. Madison in 1803. But the concept that there's a higher law that ordinary legislation must conform to is Roman. Natural law, fundamental law, the idea that not all laws are equal, that some trump others, that courts can determine which is which. Today, constitutional courts exist around the world. Germany's Federal Constitutional Court, France's Constitutional Council, South Africa's Constitutional Court, India's Supreme Court. They review legislation. They protect rights. They enforce constitutional limits. And the theoretical foundation for this is Roman. The hierarchy of laws, the supremacy of fundamental principles, the role of judges in interpreting and enforcing them. Now let's talk about international law. The rules governing relations between states, treaties, diplomatic protocols, the laws of war, human rights obligations. This is a relatively modern field, but its roots are Roman. The Romans developed ius gentium, the law of nations. Initially, it was just the law applied in disputes involving foreigners. But Roman jurists started to see it as something more. A set of principles common to all peoples, universal rules that should govern interactions between different nations and cultures. Hugo Grotius, a 17th century Dutch jurist, is often called the father of international law. He wrote about the laws of war and peace, about when war is justified, about how it should be conducted, about the rights of neutral parties, and he drew heavily on Roman sources. On Cicero, on the Digest, on Roman concepts of just war and legal obligation. Modern international law has grown far beyond what Grotius imagined. The United Nations, the International Court of Justice, the International Criminal Court, treaties on everything from trade to climate change to nuclear weapons, rules about sovereignty, about intervention, about the protection of civilians in wartime, about crimes against humanity. All of this rests on the idea that law transcends national boundaries, that there are principles that bind all nations, that even in the absence of a world government there can be legal order, that agreements create obligations, that some acts are crimes regardless of where they're committed. These ideas are Roman in origin, refined, expanded, adapted, but Roman. Take the Geneva Conventions. These are treaties that govern the conduct of war. They protect prisoners of war. They prohibit torture. They require that civilians be distinguished from combatants. They set limits on what's acceptable even in the extremity of armed conflict. Why should there be limits? Why shouldn't war be total? Because even war should be governed by law, by principles of humanity, by rules that recognize the dignity of all people, even enemies. That's natural law thinking. That's the idea that some moral principles are universal and binding. That's Roman. Or take the Universal Declaration of Human Rights and the treaties that followed. These assert that all people have rights, that governments must respect them, that the international community has an interest in how states treat their own citizens, that sovereignty isn't absolute, that there are limits. This is controversial. Many countries resist it. They say it's Western imperialism, cultural colonialism, an attempt to impose alien values. And there's some truth to that. The human rights framework was developed primarily by Western countries. It reflects Western liberal values. But it's also grounded in principles that claim to be universal, that derive from reason and human nature, not from any particular culture. That's natural law. That's Roman. Now let's talk about legal education, how lawyers are trained. In most of the world, especially in civil law countries, legal education is based on studying codes and principles. You learn the structure of the law, the categories, the logic. You study the civil code, the commercial code, the criminal code. You learn how they're organized, how they fit together, how to apply principles to specific cases. This is Roman, the idea of law as a systematic body of knowledge. as something that can be taught academically, as a science, not just a craft. Roman jurists were scholars. They wrote treatises. They debated principles. They trained the next generation. And that tradition continues. Even in common law countries, where legal education focuses more on cases and precedent, Roman influence is everywhere. The first year of law school typically includes courses on contracts, torts, property, criminal law, and civil procedure. These categories are Roman. The way the subjects are divided and organized reflects Roman legal taxonomy. And law students, in both civil and common law systems, learn Latin, not conversationally, but the vocabulary, the maxims, the technical terms, because they're still used, still necessary, still the most precise way to express certain legal concepts. So every lawyer, everywhere in the world, is trained in a tradition that traces back to Rome. They might not realize it. They might never think about it, but they're standing on Roman foundations, using Roman tools, speaking a Roman language. Let's talk about something more abstract. The rule of law. This phrase gets thrown around a lot. Politicians invoke it. Activists demand it. International organizations promote it. But what does it actually mean? At its core, the rule of law means that law, not arbitrary power, governs society. That everyone, including those in power, is subject to the law. That laws are written, public, and applied consistently. That you can't be punished except according to law. That legal procedures exist and must be followed. That courts are independent and impartial. This is a Roman concept, not uniquely Roman. Other traditions have similar ideas. But Rome articulated it clearly, built institutions around it, wrote it into legal texts that survived and influenced later generations. The rule of law is fragile. It requires constant maintenance, constant vigilance. It can erode. It can collapse. History is full of examples. Democracies that became tyrannies. Legal systems that became tools of oppression. The rule of law isn't automatic. It has to be defended. And when it is defended, when people fight for it, they're often invoking Roman principles. The idea that law should be supreme, that power should be limited, that rights should be protected, that procedures should be followed. These aren't just practical considerations. They're moral principles. They're what separate a legal system from organized violence. Today, the rule of law is considered essential to good governance. International development organizations promote it. They help countries draft constitutions, train judges, reform legal systems. They measure it, rank countries. The World Justice Project produces an annual Rule of Law Index. They assess countries on things like constraints on government power, absence of corruption, open government, fundamental rights, order and security, regulatory enforcement, civil justice, and criminal justice. All of these measures, all of these principles, trace back to ideas that Rome developed, or at least formalized. The notion that government power should be limited, that corruption is wrong, that transparency matters, that rights exist, that justice should be accessible, that crime should be punished according to law. Rome didn't invent justice, but it created a framework for thinking about justice. A vocabulary, a set of institutions, a tradition, and that tradition is alive today, everywhere, in every legal system, in every courthouse, in every law school, in every constitution. You live in a world built on Roman law. Not just influenced by it, built on it. The foundation is Roman. The structure is Roman. The logic is Roman. The vocabulary is Roman. Even when you can't see it, even when you don't know it, it's there. Every time you exercise a right, every time you sign a contract, every time you go to court, every time you vote, every time you expect the government to follow its own rules, you're participating in a system that's fundamentally Roman. And here's the remarkable thing. It works. Not perfectly. No system does. There are injustices, failures, abuses. But compared to the alternatives, compared to systems without the rule of law, without rights, without legal procedures, it's extraordinarily successful. Billions of people live under legal systems rooted in Roman principles. They own property. They make contracts. They have families. They resolve disputes. They expect justice. And more often than not, they get it. Not always, but often enough that the system functions, that society holds together, that people can plan their lives with some confidence that the rules won't change arbitrarily. That's not a small thing. That's civilization, and it's Roman. 2,000 years after the fall of the Western Empire, 1,500 years after Justinian, 1,000 years after the rediscovery of the digest, Roman law is still here, still working, still shaping the world. Not because anyone forced it, not because of conquest or colonization, though those played a role, but because it works, because it's useful, because it provides tools for organizing society, for resolving disputes, for protecting rights, for limiting power, because ideas that work don't die. They adapt, they evolve, they spread. And Roman law is an idea that worked. That still works. That will probably keep working for a long time to come. So the next time you interact with the legal system in any way, even something as simple as signing a form or reading a contract, pause for a second. Think about where it all came from. Think about the centuries of development. The empires that rose and fell. The scholars who studied. The lawmakers who codified. The judges who interpreted. The activists who fought for rights. Think about the chain that connects you to ancient Rome, invisible but real, stretching across millennia, linking your life to the lives of people who lived before Christ, before Muhammad, before the invention of paper or gunpowder or the printing press. You're part of something vast, something ancient, something that's survived everything history could throw at it. Barbarian invasions, plagues, wars, revolutions, the collapse of empires, the rise of new ones. Through it all, Roman law endured. Changed, yes. Adapted, certainly. But fundamentally the same principles, the same logic, the same commitment to law as something rational, knowable, and binding. That's the modern world, built on Roman foundations, still standing, still functioning, still Roman, even when we don't see it. Even when we don't know it, even when we take it for granted. It's there, holding everything together, making civilization possible, and it's not going anywhere. Here's something that should terrify you, how fragile all of this is. Everything we've talked about, property rights, contracts, due process, the presumption of innocence, constitutional government, human rights, the rule of law, all of it. The entire edifice of modern legal civilization. It's not inevitable. It's not natural. It's not guaranteed. It can collapse. It has collapsed many times, in many places. Throughout history, the Roman Empire itself collapsed. The western half, anyway. In 476 CE, the last emperor was deposed. The empire that had seemed eternal, that had dominated the Mediterranean world for centuries, was gone. And with it, much of Roman law disappeared. Not everywhere, not completely, but in large parts of Europe, the legal system fragmented, knowledge was lost, literacy declined, the sophisticated legal culture that Rome had built crumbled. For centuries, Europe was a patchwork of local customs and personal relationships, feudal obligations, tribal traditions, church law. Some Roman elements survived, but the system as a whole was gone. It had to be rebuilt, painstakingly over centuries, through the work of scholars who rediscovered old texts, through the efforts of kings who wanted centralized legal systems, through the struggles of people fighting for rights, and even after it was rebuilt, it wasn't secure. Legal systems can regress, rights can be taken away, the rule of law can erode. Look at the 20th century, supposedly the modern era, the age of progress. And what happened? Totalitarianism, fascism, communism, genocides, the Holocaust, the Gulag, Pol Pot's killing fields, Rwanda. the former Yugoslavia, legal systems that had existed for centuries were dismantled. Rights that had been recognized for generations were abolished. Courts became instruments of oppression. Law became a weapon. It can happen. It does happen. More often than we want to admit. The rule of law isn't automatic. It's an achievement. And like all achievements, it requires effort to maintain. So why does Roman law persist? Why has it survived for 2,000 years when empires, religions, languages, and entire civilizations have disappeared? Partly its adaptability. Roman law isn't rigid. It's not a fixed code that must be followed exactly. It's a framework, a set of principles, a way of thinking about legal problems, and it can be adapted to new circumstances, new technologies, new social arrangements, new values. When Rome fell, Roman law didn't demand loyalty to a dead empire. It could be separated from its political context, studied for its own sake, applied to new situations. Medieval kings could use Roman legal concepts without claiming to be Roman emperors. Modern democracies could adopt Roman property law without adopting Roman social hierarchies. The law was flexible enough to survive the loss of the society that created it, and that flexibility is why it's still here. Partly its utility. Roman law works. It solves problems. How do you handle complex commercial transactions? Roman contract law. How do you determine who owns property after generations of transfers? Roman property law. How do you structure a fair trial? Roman procedure. These aren't just theoretical questions. They're practical problems that every society faces, and Roman law offers tested solutions. It's been refined over 2,000 years. Countless jurists, judges, and lawmakers have worked with these principles. They've found what works and what doesn't. They've adapted, modified, improved. By now, the system is incredibly sophisticated. It's not perfect, but it's functional. And in law, functional is everything. Partly it's education. Legal education transmits Roman law across generations. Law students study it, often without realizing that's what they're doing. They learn contracts, torts, property, procedure. They learn legal reasoning, how to analyze a case, how to apply principles to facts, how to construct arguments, and all of this is rooted in Roman legal method. Once you're trained in this tradition, you think in Roman categories. You use Roman logic. You speak Roman vocabulary. And then you teach the next generation, who teach the next. The tradition perpetuates itself through education, through intellectual lineage that stretches back centuries, and partly it's institutional. Legal systems are conservative. They resist change, not out of stubbornness, though there's some of that, but out of necessity. The law needs to be stable, predictable. People make decisions based on what they think the law is. They enter contracts, they buy property, they make plans. If the law changes constantly, unpredictably, people can't function. Society breaks down, so legal systems have mechanisms to preserve continuity. Precedent, codes, legal education, professional organizations, courts. All of these institutions have an interest in stability, in maintaining the system, in preserving what works. And what works, what's proven to work over centuries, is Roman law. So institutions preserve it, not consciously, usually, not as a deliberate project to keep Roman law alive, but as a byproduct of doing their jobs. Maintaining legal stability, ensuring continuity, training lawyers, deciding cases. Roman law survives because it's embedded in institutions, and institutions are persistent. But here's the thing. None of this is automatic. None of it is guaranteed. Institutions can fail. Education can be disrupted. Utility doesn't matter if people decide they don't care about law. Adaptability doesn't help if there's no one to do the adapting. The rule of law requires defenders, people who believe in it, who understand its value, who are willing to fight for it when it's threatened. And it's always threatened by corruption, by authoritarianism, by populism, by crisis. by people who find law inconvenient, who want power without constraints, who see rights as obstacles. Every generation has to defend the rule of law, has to renew the commitment, has to fight the same battles against tyranny, against injustice, against the erosion of rights. It's never finished, never secure, always under pressure. And when people do fight for it, when they defend legal principles against power, against corruption, against authoritarianism, they're fighting for Roman ideas, whether they know it or not. The principle that law is supreme, that power should be limited, that rights exist, that procedures matter, that everyone is equal before the law, that justice should be rational, knowable, and fair. These are Roman principles, refined over centuries, expanded to include more people, made more just, but fundamentally Roman. Think about the civil rights movement in the United States. Activists fighting against segregation, against discrimination, against laws that treated people differently based on race. What did they invoke? The Constitution, the 14th Amendment, equal protection of the laws, the principle that law should be applied equally, that distinctions based on race are illegitimate, that everyone has rights. That's Roman. The concept of legal equality, the idea that law should be impartial, the use of courts to enforce rights, the belief that unjust laws should be struck down, all of it rooted in Roman legal thought. Or think about anti-corruption movements around the world, people fighting against governments that steal public money, that rig contracts, that sell justice to the highest bidder. What are they demanding? The rule of law, accountability, transparency, the principle that officials should be bound by law, that they can't just do whatever they want, that they should be held accountable if they violate the law. That's Roman. The idea that even those in power are subject to law, that public officials have duties, that they can be prosecuted if they abuse their positions. These concepts come from Rome, from the Roman Republic's struggles to constrain magistrates, from Roman law's insistence that authority comes with responsibility. Or think about human rights defenders, people documenting abuses, demanding that governments respect fundamental rights, advocating for prisoners, for refugees, for minorities, for the oppressed. What framework do they use? Human rights law, international treaties, constitutional protections. The principle that certain rights are universal and inalienable, that governments have obligations, that individuals have dignity that must be respected. That's natural law. That's Roman philosophy filtered through centuries of development. The idea that there are moral truths, that law should reflect them, that rights exist whether governments recognize them or not. All of these struggles, all of these movements, all of these fights for justice, they're using Roman tools, Roman concepts, Roman language, standing on Roman foundations. And when they succeed, when they achieve change, when they make the world a little more just, they're proving that Roman law still matters, that it's not just historical curiosity, not just academic interest, but a living tradition that shapes real outcomes, that protects real people, that makes real differences. Now let's talk about the future. Where does Roman law go from here? It survived 2,000 years. Will it survive another 1,000? Honestly, who knows? The world is changing fast. Technology is transforming everything. Artificial intelligence, biotechnology, space exploration, climate change. These create legal challenges the Romans never imagined. How do you regulate AI? Who owns genetic information? What law applies in space? How do you hold countries accountable for carbon emissions? Roman law doesn't have answers to these specific questions, but it provides a framework for thinking about them. How do you define property? What creates obligations? How do you balance individual rights against collective interests? How do you create rules that are fair, effective, and enforceable? These are Roman questions. The contexts are new, the technologies are new, but the fundamental legal problems are the same. Ownership, obligation, liability, procedure, justice. And the tools for thinking about them, the categories and concepts and methods, those are still Roman. Will they remain Roman? Or will we develop entirely new legal frameworks? New ways of thinking about law that leave Roman categories behind? Maybe. Law evolves. It has to. New problems require new solutions. And sometimes old frameworks become obsolete. They stop working. They stop making sense. And they're replaced. But legal change is slow. Conservative. Institutions resist it. And there's good reason for that. Stability matters. Predictability matters. You can't just throw out 2,000 years of legal development and start over. Even if you wanted to, even if you thought you could build something better, the transition would be chaotic, destructive. So more likely, Roman law will continue to evolve, adapt to new circumstances, incorporate new concepts, but remain fundamentally Roman. In its structure, in its logic, in its vocabulary, just as it absorbed feudalism and Christianity and Enlightenment philosophy and liberalism and human rights. Just as it adapted to capitalism and democracy and globalization, it will adapt to whatever comes next. AI, gene editing, climate crisis, space colonization. Whatever challenges emerge, Roman law will probably bend to accommodate them, because that's what it does. That's why it survived. It bends. It adapts. It evolves. But it doesn't break. The core principles remain. Property, contract, tort, procedure, equality, justice. These concepts are flexible enough to apply to almost any situation, and they're useful enough that people keep using them. So yes, Roman law will probably survive, not unchanged. Not in exactly its current form, but recognizably Roman. Still providing the framework, still shaping how we think about law, still holding civilization together. Unless, of course, civilization collapses. That's always possible. Climate change, nuclear war, pandemic, civilizational collapse. If that happens, legal systems collapse too. Roman law won't help you in a post-apocalyptic wasteland. You'll be back to might makes right. Back to survival. But if civilization survives, if we navigate the challenges ahead, if we maintain some kind of legal order, it will probably be Roman in its foundations. Because we don't know how to build anything else. Because the alternatives, customary law, religious law, authoritarian decree, they work less well. They're less flexible, less just, less able to handle complexity. Roman law isn't perfect, but it's the best system we've developed for organizing large, complex, diverse societies, for protecting rights, for enabling commerce, for resolving disputes, for limiting power. And until we develop something better, we'll keep using it. So here we are, 2,000 years after the 12 Tables, 1,500 years after Justinian, living in a world the Romans couldn't have imagined, with technologies they never dreamed of, with values they didn't share, with challenges they never faced. And yet, we're still using their law, still thinking with their categories, still speaking their language, still building on their foundations, not because we're stuck in the past, not because we're incapable of innovation, but because what they built works, because the principles they developed are sound, because the framework they created is adaptable enough to handle problems they never anticipated. That's not nostalgia. That's not romanticism. That's recognition of something real, something valuable, something worth preserving. Roman law endures because it deserves to endure, because it's useful, because it's just, or at least it aims toward justice, because it creates order without tyranny, freedom within structure, rights protected by law. Is it perfect? No. Does it always deliver justice? No. Are there better alternatives? Maybe. Someday, but not yet. Not that we've found. So, we keep using it. Keep building on it. Keep adapting it. Keep defending it. Keep teaching it to the next generation, because it's what we have. And it's pretty good. And losing it would be a disaster. The marble halls have crumbled. The aqueducts are ruins. The roads are buried. The legions are dust. The emperors are forgotten by everyone except historians. But the law remains. The principles, the concepts, the framework, the tradition, still alive, still functional, still Roman, and probably, hopefully, still here 1,000 years from now. Changed, evolved, adapted, but recognizable, still providing the foundation for how humans organize themselves, how they resolve disputes, how they protect rights, how they create justice, still Roman. After all this time, after everything, still Roman. That's the persistence of Roman justice. Not physical, not political, but intellectual, conceptual, institutional. A way of thinking about law that's proven so useful, so adaptable, so fundamentally sound that it's outlived the civilization that created it. And it will probably outlive ours too. Whatever comes next, whoever builds it, they'll probably use Roman tools, Roman concepts, Roman logic, because some ideas are too good to die, too useful to abandon, too true in some deep sense to forget. Roman law is one of those ideas, and it's still here, still working, still shaping the world, still Roman, always Roman, forever Roman. So let's come back to where we started, to you, to right now, to this moment. You're lying in bed, or sitting in a chair, or walking somewhere with headphones in. The world around you is modern, electric lights, running water, smartphones, the internet, things the Romans never imagined, things that would seem like magic to them, like miracles, and yet, beneath all of it, beneath the technology and the modernity and the forward march of progress, beneath the glass towers and the fiber optic cables and the satellite networks, there's something ancient, something that refuses to die, something that's been there all along, so long that you stopped noticing it. Roman law. Not as decoration, not as history, not as some dusty academic subject that doesn't matter anymore, but as the living, breathing foundation of the world you inhabit, the framework that makes everything else possible. The plumbing, as we said before, invisible but essential. You woke up this morning in a bed you own or rent. Property rights and contract law made that possible. Roman, you got dressed in clothes you purchased. Another contract. You ate breakfast with food you bought. More contracts. You checked your phone, a device you own. Property law. You scrolled through news about court cases, new laws, political disputes. All of it happening within legal frameworks that are fundamentally Roman. Every single thing you did today. Every interaction with the legal system. Every assumption you made about how society works. Every expectation you had about your rights and your obligations, all of it shaped by Roman law, structured by Roman concepts, expressed in Roman vocabulary. And you didn't think about it. Why would you? It's just normal. Just how things are, just the water you're swimming in. But it's not normal. Not in the sense of natural or inevitable. It's the product of 2,000 years of continuous development, of empires rising and falling, of scholars studying and debating, of lawmakers codifying and judges interpreting, of activists fighting and reformers pushing, of revolutions and wars and social movements and constitutional conventions. All of that history, all of that struggle, all of that intellectual work. It's embedded in the legal system you take for granted, in the rights you assume you have, in the procedures that protect you, in the rules that govern your daily life. Think about what would happen if it disappeared. If tomorrow, suddenly, there was no legal system, no property rights, no contract enforcement, no courts, no police, no laws, just people and power and violence. How long would it take for society to collapse? How long before everything fell apart? Days? Hours? You wouldn't be able to own anything. Not really. Because ownership only means something if someone enforces it. If there's a system that says this is yours and prevents others from taking it, without that, everything belongs to whoever's strong enough to take it and keep it. You wouldn't be able to make agreements, because promises without enforcement are just words. Why would anyone honor a contract if they could break it without consequence? Why would you trust anyone? Commerce would stop. Cooperation would stop. Everyone would be on their own. You wouldn't have rights. Not in any meaningful sense. Rights are legal constructs. They exist because legal systems recognize and protect them. Without that, you have only what you can defend by force. The strong dominate. The weak suffer. That's it. This is what life looks like without law. And it's not theoretical. It happens. Failed states, war zones, collapsed governments, places where the legal system breaks down, and what you see is horror, violence, chaos. The strong preying on the weak, no justice, no protection, no peace. Law is what prevents that. Legal systems are what make civilization possible, and Roman law is the foundation of most legal systems in the world. The blueprint, the framework, the tradition that makes it all work. So when you take law for granted, when you assume it's just there, when you don't think about where it came from, or how it works, or why it matters, you're missing something important. You're missing the fact that you're living on borrowed time, on accumulated wisdom, on the efforts of countless people across countless generations who built and maintained and defended this system. You're standing on the shoulders of Roman jurists who studied and debated 2,000 years ago, of medieval scholars who preserved and transmitted their work, of Enlightenment philosophers who expanded and refined their principles, of revolutionaries who fought for rights, of lawmakers who codified, of judges who interpreted, of activists who pushed for justice. All of them contributed. All of them are part of the chain that connects ancient Rome to your life right now. And that chain is unbroken, continuous, stretching across 2 millennia, linking you to the past in ways you probably never realized. And here's the thing, it's not just history. It's not just interesting trivia. It's relevant, urgent even. Because legal systems aren't automatic. They don't maintain themselves. They require active defense, constant vigilance, continuous renewal. Every generation faces threats to the rule of law, to rights, to justice. Sometimes the threats are obvious. Authoritarians who want to concentrate power, corrupt officials who want to operate without accountability, violent extremists who want to overthrow the system entirely. Sometimes the threats are subtle: erosion of norms, weakening of institutions, politicization of courts, attacks on judicial independence, disrespect for legal procedures, contempt for constraints on power. And sometimes the threat is just apathy, people not caring, not paying attention, not defending the system when it's under attack, taking it for granted until it's gone. Roman law survived 2,000 years, but that doesn't mean it's invincible. It can die. It has died in places, and it can die again if people stop defending it, stop believing in it, stop teaching it, stop using it, stop caring about it. So maybe that's the real lesson here. Not just that Roman law exists, not just that it shaped the modern world, but that it's fragile, precious, worth protecting. The rule of law isn't a given, it's an achievement. Rights aren't automatic. They're fought for. Justice isn't natural. It's constructed, painstakingly, over centuries, by people who believed it mattered. And it does matter, more than almost anything else. Because without law, without rights, without justice, you have nothing. No security, no freedom, no dignity, just power and violence and fear. With law, imperfect as it is, you have a chance. A framework for resolving disputes without violence. A system for protecting the weak from the strong. A set of principles that limit what the powerful can do. A foundation for building a decent society. That foundation is Roman, and it's still here. Still working, still making civilization possible. But only if we maintain it. Only if we defend it. Only if we remember where it came from and why it matters and what would happen if we lost it. So the next time you interact with the legal system, The next time you sign a contract, or go to court, or vote, or exercise a right, or expect the government to follow its own rules, pause. Think about it. Recognize what you're participating in. You're part of a tradition that stretches back 2,000 years. You're using tools developed by the sharpest legal minds in history. You're standing on foundations laid by people who've been dead for centuries, but whose ideas are still alive, still relevant, still essential. You're connected to ancient Rome, not through blood, not through nationality, not through language or culture, but through law, through shared principles, through a common legal tradition that transcends time and place. The Romans are gone. Their empire collapsed. Their language died. Their cities crumbled. But their law survived. And it's yours now. It belongs to you, not because you earned it, not because you built it, but because you inherited it, because generation after generation preserved it and passed it down until it reached you. And now you have a responsibility, not a legal obligation, but a moral one, to understand what you've inherited, to recognize its value, to protect it, to pass it on. Because legal systems don't maintain themselves. They require each generation to renew the commitment, to defend the principles, to fight for justice, to believe that law matters more than power, that rights matter more than might. That civilization is possible and worth preserving. That's what Roman law represents. Not perfection, not final answers, but a framework for pursuing justice, a set of tools for organizing society, a tradition of believing that law should be rational, knowable, and binding on everyone. It survived everything history could throw at it. Barbarian invasions, plagues, wars, the collapse of empires, the rise of new ones, revolutions, dictatorships, 2 world wars, the nuclear age, the information age. Through it all, Roman law endured, changed, adapted, evolved, but fundamentally the same. Still Roman in its bones, still recognizable, still functional, and it's here now. In your life, in your world. Holding everything together, making everything work. Invisible but essential. The marble halls of Rome may have crumbled. The forums may be ruins where tourists take selfies. The aqueducts may be broken. The roads may be buried under modern highways. The legions may be gone. The emperors may be dust. But the laws, the principles, the concepts, the framework, the tradition, they're still here, still alive, still governing the world, still protecting rights, still enabling commerce, still resolving disputes, still limiting power, still making civilization possible, still Roman after all this time. After everything that's happened, after 2,000 years of change and chaos and progress and setbacks, still Roman. That's not an accident. It's not luck. It's because Roman law works, because the principles are sound, because the framework is adaptable, because the tradition is resilient, because generation after generation chose to preserve it, to defend it, to build on it, to pass it on, and now it's your turn. You're part of this now, part of the chain, part of the tradition, whether you want it to be or not, whether you realize it or not. You're living in a world built on Roman foundations, using Roman tools, speaking a Roman legal language, participating in a Roman legal tradition. So maybe think about that, maybe appreciate it, maybe defend it when it's threatened, maybe teach it to the next generation, maybe contribute something, however small, to the ongoing project of building a more just world. Because that's what this is, an ongoing project. Never finished, never perfect, always incomplete, always needing work, but possible, achievable, worth doing. The Romans started it, but they didn't finish it. Nobody ever will. Law is never finished. Justice is never complete. The work continues, generation after generation, building on what came before, adding their own contributions, passing it forward, and you're part of that. Right now, today, in whatever small ways you interact with the legal system, in whatever assumptions you make about rights and obligations, in whatever expectations you have about how society should work, you're carrying forward a tradition that's older than Christianity, older than Islam, older than most of the world's great religions and philosophies and civilizations, a tradition that survived everything. That's proven itself across 2,000 years. That's made the modern world possible. That's not nothing. That's everything. That's civilization itself. Fragile, imperfect, constantly threatened, but still standing, still working, still Roman, so here you are. At the end of this journey, this long walk through 2,000 years of legal history, from the 12 tables to Justinian's Code, to medieval universities, to Enlightenment philosophy, to modern constitutions and human rights. From ancient Rome to right now, to you, to this moment. And what have we learned? That law matters. That it's not just rules and procedures and boring legal jargon. That it's the foundation of everything. Of your rights, your property, your relationships, your security, your freedom, your ability to live in something resembling a civilized society rather than a violent free-for-all. That law has a history, a lineage, a tradition. And that tradition is Roman. Not exclusively. Other cultures contributed. Other traditions influenced. But the skeleton, the framework, the core concepts, they're Roman. That this matters. Not just academically, not just historically, but practically. Right now. Today. Because the legal system you live under, the rights you have, the protections you enjoy, they all rest on Roman foundations. And those foundations need to be maintained, defended, preserved for future generations. So maybe next time you wake up, you'll see things a little differently. You'll recognize the invisible hand of Roman law shaping your world. You'll appreciate the centuries of work that went into building the legal system you take for granted. You'll understand that you're part of something larger than yourself, something ancient, something enduring, something worth protecting. Maybe you'll be a little more grateful for the rule of law, a little more vigilant in defending it, a little more aware of how precious and fragile it is, a little more conscious of your role in preserving and passing it forward. Or maybe not. Maybe you'll forget all of this by tomorrow. Go back to taking it for granted. Stop thinking about where it all came from. That's okay too. That's human. We can't walk around constantly aware of everything. We have lives to live, problems to solve, days to get through, but somewhere in the back of your mind, maybe this will linger. This awareness that you're connected to ancient Rome, that their law is your law, that their tradition is your tradition, that their dream of a world governed by law, not by violence, is still alive, still being pursued, still within reach. And maybe, when it matters, when the legal system is threatened, or your rights are under attack, or someone's trying to undermine the rule of law, you'll remember. You'll understand what's at stake. You'll recognize that this isn't just politics or policy. This is civilization itself, the thing that separates us from chaos, the framework that makes everything else possible. And maybe you'll fight for it. Defend it. Speak up. Vote. Protest. Whatever it takes. Because it matters. Because losing it would be a disaster. Because once it's gone, rebuilding it takes centuries. If it can be rebuilt at all. That's the real message here. Not that Roman law is perfect. Not that we should worship the past. Not that ancient is automatically better. But that we've inherited something valuable. Something that took 2,000 years to build. Something that works, imperfectly but functionally. Something worth keeping. The marble halls have crumbled. The forums are silent. The emperors are forgotten. But the laws continue to govern the living world. Quietly, rationally, invisibly, forever Roman. That's where we started, with that image, with that idea. And that's where we end. Because it's true, it's not poetic exaggeration. It's literal truth. Roman law governs the living world. Your world. Right now. Today. and it will probably keep governing long after you're gone. Long after your children are gone. Long after your grandchildren are gone. Because some ideas are too good to die, too useful to abandon, too fundamental to replace. Roman law is one of those ideas. And as long as humans need rules to live together, need systems to resolve disputes, need frameworks to protect rights and limit power, it will endure. Changed, yes. Evolved, certainly. Adapted to circumstances the Romans never imagined. But fundamentally the same. Still Roman in its core. Still built on principles developed 2,000 years ago. Still using concepts and categories and logic that trace back to the 12 Tables, to Justinian's Code, to the great jurists of the classical period. Still Roman. Always Roman. Forever Roman. So rest well, sleep peacefully, dream whatever dreams you dream, and know that while you sleep, while you wake, while you live your life, Roman law is there. Working, protecting, holding everything together. The eternal return, the law that refuses to die, the tradition that outlived its empire. The Roman ghost that haunts every courthouse, every contract, every constitution in the modern world. Not gone. Never gone. Still here. Still Roman. And that's not going to change anytime soon. Good night, and thank you for listening.